Your pleasure, Lordship. Lordship, I beg to mention a bail application for listing for tomorrow, Your Lordship.
Tomorrow?
Tomorrow, Lordship.
Because we are similar time. For tomorrow, also tomorrow. May I please, Your Lordship? I beg to item number 18, Your Lordship, may be possible for today, Your Lordship. 18. May be possible for today, Your Lordship. Adjournment for the day. Any listing date you want? List after vacation. List after vacation.
I'm paying for listing, but we can give it Friday goes.
Right.
I have filed it on 5th of September. Right.
May it please your lordship. Your lordship, item number 45, may it be possible for the day, your lordship. 45.
Is there a receipt?
Case diary was received on the last location only. Your lordship, it was some time was sought by the London PP or the last location.
Keep the case there and fix it on Monday.
Your lordship, after vacation in
After which. So it will not be possible to retain the case there. Isn't it? Send back. No, interim has to be extended. So long. Should we let us wait that matter? Or I can see it at 2 o'clock. Just see it at 2 o'clock. Hello, driving to this like number 59 from submission. I will be going to this by 59. Withdraw this case. Mr. Azad, Learned Counsel submits that we have instructions to withdraw this bail petition. The prayer is allowed. Bail petition dispose of upon its withdrawal. 59.
May I please, your lordship? Lordship, I beg to mention item number 51, lordship. Lordship, case there is available in this case. Lordship, we intend to bring some document by filing additional affidavit. In the meantime, matter may be passed over for the day, lordship. And maybe fixed on the next week, lordship. Any date, lordship.
Learned Counsel seeks an adjournment to file an additional affidavit, bringing on record certain documents. Prayer is allowed. Case diary is available and shall be reading. Next week, Monday.
Lordship, okay, can it be on Wednesday, lordship?
24 9.
Deeply obliged.
Case that is not received. I want to pay.
Not received. Item 50, case diary not received. List next week or after vacation? List the matter after vacation on. That is better to give a date. 1710. Interim bill shall stand extended. Granted by order dated so and so shall stand extended till the next date of listing.
May I please, your lordship? Lordship, I beg to mention an IA listing.
I for listing.
IA.
Today.
Tomorrow.
Tomorrow. Okay.
Okay.
I bail petition for listing on 19 September. Same petitioner was yes. He wrote that 7 years of punishment. On 19 September.
Lordship, I beg to mention item number 31. May the matter be passed over for the day and be listed any day next week, my lord.
That is received.
So next week.
We can retain the same. How about 23rd? Okay. Item number 31.
31.
Since an adjournment. For the day, which is allowed. Case diary shall be reading list on 23/9/2020.
I have it as item number 9.
9.
And the matter will be passed over for the.
Motion.
Maybe
Just a minute. Adjourn for the new matter. Adjourn for the day. List, you want a date next, better to fix a date. After vacation. This prayed that the matter might be listed after vacation. List on 1710.
May I please, lordship? So I want to mention regarding listing of the criminal record of 2022 lordship on Friday.
Right, criminal offense.
Yes, Lordship. Which one?
Right.
Let's see.
I can. So no problem, but I don't.
Lordship, connected matters, it was last listed on 8/9/2025 and fixed for today, Lordship.
Connected matter.
Yes, Lord.
So connected matter. So you want it on 19. No, so 19. There is, it's a new matter, or diary.
Lordship, postmortem report was called for. Lord.
Why not tomorrow? Yeah, tomorrow you.
Yes, Lord. Highly obliged.
May it please your lordship. Lordship, I beg to mention an interlocutory application criminal for listing, my lord. And the main application, which is AB number 1987, is already listed tomorrow before your lordship at item number 40, my lord.
Will
This is for extension. Will come up tomorrow with the bail application. That's my plan. Obliged, lordship. Lordship, the filing number would be provided in a few minutes. I beg for a few minutes time to submit the memo. Obliged, my lord.
May bring it also. What's the back to mention for listing bail application also? For motions and recommendations.
tomorrow.
Plus, oblige it.
May I beg to mention this for listing bail application for tomorrow.
Tomorrow, day after. Tomorrow. Any matters will be day after tomorrow.
Item number 7. Let's say, let it come on Friday.
New matter.
Yes.
Can it be on Monday? Monday. 7. Adjourn for the day. List on 19.
Lordship, in item number 37, CD is not available. Yeah, in
30?
interim,
37.
37. And date may be fixed on after vacation.
You're an interim.
Yes.
His diary is not available. After vacation. His diary is not available. This is the matter. After vacation on 17/10, interim bill. Granted by order dated so and so. Stands extended till the next date of listing.
Highly approved.
Tomorrow.
May I please your lordship, I beg to mention item number 40, lordship. In this matter, probably CD has not received lordship. And we are in interim lordship, so interim may continue.
Should we take it up? Should we take it up? At that time, if necessary, we'll let you.
Lordship, obliged.
This is regular bail application of fees. Petitioner is eligible to custody lordship 34 days lordship. So, FR will find page number 10. Some pan masala has been under, one truck is hijacked by some other person lordship. Then subsequently lordship, then there is the phone call was found to the arrested accused person. On that basis, lordship, I have been arrested, lordship. For a moment, lordship, page number 16, lordship, forwarding report. 16, 16. The ground of arrest, lordship. May I read, lordship? Ground of arrest number 1. 26 number of cartoons worth approx rupees 4 lakhs are yet to be recovered, and if the accused are bailed out, they will dispose the same. And 4 accused have been identified from the interrogation and CDR analysis, and they are yet to be arrested. Well, we are already in custody lordship. And the arrested accused have been formed a gang, doctrines, and are habitually involved in such cases, crimes. And if they are released on bail, they will be so. But in my arrest lordship, and nothing has been recovered from my possession lordship. And last 6, number 6 lordship. The arrested accused are from interior areas of Bhopal and Soigao, and they will surely abscond during the trial. On that basis, 34 days in the
Same would be. Yes, very. So I think your connected bail application, it's some date, I think. Anyway, remember. bottom of this is 61. We have to start. I don't remember the dates.
Maybe
I-
Lordship on 19, maybe
Not
Lordship.
sure, I'm not sure.
Can
Third,
be Lordship.
of learned counsel and SH for learned additional people. Call for the case diary of Borama PS case number 61 of 20. Section so and so. The present accused was arrested on
Okay, to forward is 22.
Lordship, 13/8/2025.
arrested and forwarded on 13/8/2025. List the matter on
26 Lordship.
Hmm?
26 Lordship.
We'll keep it for the last day. This is the connected matters might be on Friday, but they're likely to be on Friday. You are not there. They are not sure. So in that
Nine,
Friday,
maybe 19.
maybe 19. So okay, let us keep it for 23rd or 22nd, 23 9
Lordship. If you,
for bail here.
oblige.
That yeah, I will also get at page 10. And the investigation also that charge sheet is submitted in the present case. He was arrested on? Arrested on lordship 11/5/25. Now lordship may kindly say that initially the FIR was registered under section page 12, your lordship will get 3032 and page 12. During that period, I filed bail application before the trial court, but while filing the charge sheet, they added one section that your lordship will get in the charge sheet, that page 4. Against me, your lordship will get at page 26. That is 317 subclause 2 is there. That is habitually dealing in stolen property. 413 earlier. But if your lordship see the this person is A4. Lordship. No, Chandan Namoda. Chandan yeah. A4. A4. Page 26. That, but if your lordship see the details mentioned in the charge sheet, that criminal antecedent about criminal antecedent not applicable. No cases are found, but still they have mentioned that section. Page 26 lordship will get provisional criminal number and a not applicable, regular criminal number if no non-applicable, not applicable. Nothing is there that any details that earlier he was involved in similar activities. Nothing is there. And because of this scholarship, my case was rejected because it is a sessions triable case and the case is pending before the commission court. And in the charge sheet, your lordship will get that page 27. That A6 was released on bail after giving him notice under section 35(3). 26. Yes, page 27. 27. Yes, A6. 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 And similarly, A7 also page 28, he was also released on bail by giving 35(3) notice. Because at that point of time, that 317 was not there. And A8 is still absconding. So there is no chance of committing the case at an early date. So that page 28, A8, your lordship will get that he is an absconding. And I have enclosed all the. Our present accused is my accused is A6. Chandan Namodas. A4, I'm sorry. A4, which page 20. Ahmed learned concept for the accused. Chandan Namodas was arrested in connection with going off PS case number 73 of 25 under section 353 within bracket 5 slash. That is 303 Manikpur PS. So it was subsequently transferred. Oh, I see. Manikpur PS 39 of 25 under section 3 in bracket 5 3032 PNS. He was arrested on 11/5/2025. The case has been charge sheeted against he has 8 accused persons. The present accused has been labeled as A4. Copy of the charge sheet has been annexed. Third, essence for a learned additional. Proof. All for scan copy of the case diary and the charge sheet.
Yes.
Charge sheet and case diary will do. Yes. When should we list this?
Because I have enclosed all the visual list.
Many cases are listed. Many cases.
I have enclosed all the visual list also. There is nothing was recovered from his position.
Enclosed.
Yes, those are enclosed page 32 to 51. All visual list I have enclosed. Page 23 to 30. 32 to
Let's
50.
take a chance. Let's see. If it doesn't come, then if it doesn't come, then we can see what can be done. 24? I don't know whether it comes. Anyway, 24 or 25? 25. 25 9.
That records will come from the committal book. That's it. Yeah.
No, not see again. From the learned code bill. Learned
Okay.
code bill. Raised you take steps.
Okay.
CD and CS annexed, but just call for that.
It was a regular bail lordship. He was arrested on strength of the NBW issued by the court lordship. And this is not the first time. Earlier also he defaulted lordship. The page 14 is the order. Page 32 and extra 14 is the order. The page of 302, this suspect is that his this one.
It is white.
Page 32 is the last order. On 37, 2025, he was arrested.
Charge sheeted case, right?
Well, such a trial is going on. 4 or 5 witnesses have been PW has been. Only the ground that rejection is that he earlier also defaulted. That was the ground for the rejection of his petition. No, that is true, Lord. The admitted fact. It is admitted fact, and I also admit that I was previously also default was there.
No,
I was there.
Ask for testimony learned counsel. The person accused is facing trial in connection with sessions case number 12 of 2019. Arising out of board for PS case number 13 2005. Pending in a court of learned session judge by your law. Stop. It is submitted that the case the present accused was arrested on the strength of NBWA, was earlier before. Presently in judicial custody. Word each of passage for a learned additional all for scan PCR.
Then lordship, I am already admitted lordship that earlier also default was there lordship.
That is why-
Come lordship.
Deposition. When you say. Call for the scan PCR. Along with copies of depositions. Scan copies of depositions. List on 25.
Much obliged. Their lordship, what happened in this case, connected case are already fixed on lordship 19 law. BA 2841 and BA 2963 lordship.
Same effect. Earlier.
No, I'm not earlier. There is item 2. Two connected cases are fixed on 19.
Can fix this on 19. The CD comes. Still you can write. Call for case diary of Palmuzar base case 59 of them. Is submitted that connected matter is fixed on 19 September. List on 19/9/2020 for failure.
BA numbers are required.
Along with BA number.
BA number 2841-25 and BA number 2963 of 25. In this case, Lordship, case diary will be required, Lordship. May I pray before prior puja, Lordship? Prior to puja, Lordship.
But the present accused was arrested on 5/8/2020 in connection with Rehab case number 171. Call for the case diary. List on 25/9.
Lordship. Much obliged, your Lordship.
Much obliged.
Say regular bail application was connected matters are fixed on 19th. So let it be fixed on 19 was sitting in call.
Or senior person. Said call for the case diary of Matasil Ambari case 127. Some connected bail application was stated to be fixed on the same day. In the list on 19/9. Okay.
Deeply.
AB. Wait. Wait.
Wait, please, Your Lordship. The petitioner before your lordships have approached this honorable court seeking a pre-arrest bail application. My lord will kindly see the FIR at page 14, the translated copy, my lord.
Page 14.
1/4, my lord. No, my lord, the allegations are serious in nature, but the case of, yes, my lord. But the case of the petitioners is that there are witnesses, as per my instruction, my lord, there are witnesses who have stated before the police authorities that they have seen two persons and both are nephews of this present deceased in the place of
Both are
nephews
Yes.
of this present deceased. I will not pray for any interim, my lord, but only a date before the puja.
Fair. But yes, that's true.
My lord,
She was supposedly gone to collect some money.
my lord,
And we don't know.
yes, my lord. My lord.
Some anticipatory work will be. Some anticipatory stuff.
Oh, my lord. Before vacation, if possible. We can take a chance.
I don't know that it's possible, but it's all a little bit overtime. I initiate. But that will be a challenge. Obviously. I want to keep what 1 day margin, 25.
20%.
Your good name, please.
Came on.
Came on. Also. Who really submits that is only praying for only the same case diary at least. Also the case diary of Nankasar, PS case number 87 of 25.
My lord.
Under section 103. Along with postmortem report, PM report available. List on 25.
I'm deeply.
Please, Your Lordship. Someone has mentioned item number 9 wrongly, my lord. It's my item.
Is it? Item number 9. Maybe he has mistakenly mentioned the number. Might be some other. Anyway, come to know when it is called up. 9 is your matter. You can take up. And 10 also. Go ahead. 9.
Pre-arrest bail application, my lord. FIR is case number 12.
Previous injuries. You can get the CD and medical record at this case.
Except 553 clause 3 or sections are bailable. And in connection with this case, one person was arrested and at the time of production only he has enlarged on bail. And the learned Ilaka magistrate observed that perusal of the FIR and the CD available, no case is made out against section 353 sub clause 3 because it still with the public mischief at the place of religious places.
353,
353 sub clause 3.
others are available.
Others are bailable. Commission often specified in subsection 2 in any place of worship or in any assembly engaged in performance of religious worship or religious ceremony, certain punishment imprisonment is made. So this is not a place of worship or religious worship place. So this section is not accepted in this case. Rest, all other sections are valid. And that has been observed by the trial court also at page number 19 of this bail application.
But previous assault section has not been given. The allegation is about causing grievous. But grievous assault,
It's also
only
bail-
dangerous weapon is not there. But the other one is available. Voluntarily causing grievous assault is available.
Page number 20, the elements are discipline must. Has been registered under section so and so, which are available in nature except section 353 sub clause 3 DNS on and on perusal of the contents of FIR, the section 353.
Yeah, I've read it. Any submission? Possible. Please correct. Word, you would need please.
P. Mishra. P. Mishra.
Same issue. And counsel. The two petitioners here in this one. The second, anticipatory bail in connection with Jalpari PS case number 359 of 2025, the sections of the. The case arose out of an FIR dated 15/8/25. Lost by one Baru Chetri. The allegations that the accused person's name there. They're trying to use this house for consuming liquor upon being obstructed. Subsequently, they forcefully entered their house and committed assault upon him, including later, they also assaulted his wife, 12-year-old son, and brother, causing grievous injury. The learned counsel has drawn my attention to the ingredients of section 253 sub clause 3 DNS. And submits that the same is not applicable and that the other penal provisions are available. Here was the order dated 20/25 passed by learned additional sessions, where similar observation has been made. Nevertheless, call for the case diary of Jalupari case. However, in the interim, the event of arrest of the petitions in connection with this case, large on bail, 25,000 satisfaction of arresting was ordered, subject to the condition that they shall cooperate with the investigation, appear before IO for examination, not cause any harm or annoyance to the informant or his family. You can list it after petition. 22nd of October. List on 22/10. For case diary and medical.
DPR.
FIR in case number 19 months. Second FIR number similar,
Page 19.
yes, 19. Customer taking loan on the bank.
Lodged by the bank official, regional manager.
Yes.
This person is
Unless the petitioner is nowhere connection is for only events like that manner. One the open one is took his name, petitioner's name.
forgery committed by. Fraudulently taking loan.
Yes, Sunil Khanna, they are now recalled.
Why is he apprehending arrest?
But this in this connection, one open people may not take my names, man.
Oh, yeah, this accused person.
Yes, ma'am. I stated in paragraph 2 and 3. And similar, one affair is wisdom, and in that case, petitioner got bail. And it is also an expert. In page number 24.
Possibly some documents might have been typed at his place. Maybe something of that sort. Anyway,
The intent section is even said.
let him record his statement. Apparently, there are serious allegations, not name. That's the possibility. Something might have been typed in his place. The computer typing business. So, police may want to examine. Not necessarily arrest you. Apprehend, that's where they come. Mr.
Kekolita.
Nicolita Learned Counsel, assisted by Kashyap. For the petitioner Sankobar, seeking anticipatory bail in connection with Insukia PS case 367/24 under section like this. The allegation, sorry, the FIR has been lost by bank official, in bracket, regional manager of SBI. The gist of the allegations is taking of loans by fraudulent means by Nurul Haq and some other persons named in that file. But as it's more a learned edition, it submits that the allegations are serious and fall in the domain of fraudulent financial crimes. All for the case diary of Mitsukiya PS case. The question of interim bail paid for by the Learned Counsel, cash. I find that the petitioner is not named in the FIR. Nor did I notice any specific allegation against him. He stated and submitted that the petitioner is doing a computer typing works. Therefore, at this stage, he may be given an opportunity to cooperate with the investigation. Accordingly, it is directed that in the interim, in the event of arrest, in connection with this case, bail of this. 20,000 once year, that's section. Arresting standard. Subject to the commission of corporate investigation. Semicolon. Appear before the IO for examination. Not hamper or temper. This is the matter after petition on 22nd page. 22. Black.
My pleasures. Here all the petitioners are regularly number 1 and 5 are businessmen, 2, 3, 4 are student, 6 is driver university. Here is page number
9.
allegation to attack the police unit.
Right. You want to read it or should I read?
And here the user university and university.
Yeah, this one, original. Check.
Second paragraph.
Part is illegible.
Tax.
That will go.
Honorably Farooq Ali, Your Lordship, that police attempted to arrest this Farooq Ali, Your Lordship.
Who are these persons?
Where the villager, Your Lordship.
And this kind of, let us get the case there.
Several cases, Your Lordship. Some altercation took place. All allegation of the attack is false. A paper protected, Your Lordship.
Very, that's like, that's the nature of the allegations. But anyway, let us-
A paper a date before the case.
Right.
But which was about better.
Third,
Yeah.
yeah, right. The sixth petitioners hearing seeking anticipatory bail in connection with corporate affairs case number 201. Here was the fire, all for the case there, along with anything else. For example, the case there, station, based on 24, 24/9.
Yes. Please.
Yeah, this is all. Number 482 application. Lawsuit may kindly come to case. 17. Fire, 17. Mary Mala. Yes. I.V. Borua, daughter of late Abdul Latif Borua, residing at KB Road, North Lakshmipur, Assam, hereby lodged his FIR against the following person for city, forgery, criminal conspiracy and fraudulent sale of any lane without my consent. Now, my lord, name of the accused is one Imranul Latif Borua. Now, he is the petitioner here, my lord. Two Anar Ali and Mandol and Sulema Begum. My lord, these two and 4 are the my lord purchaser of my land.
So I am concerned to Malad Imranul Latif Burwa. Malad, kindly come to the facts of the case. The accused Imran Latif Burwa, in connivance with Anar Ali, illegally sold my land measuring 3 katha, patta number 37, dark number 140. Registered on so and so, and 1 katha, patta number 37, dark number 243, registered on that is so and so, in village of Saboti, Moses, Saboti under North Lakhimpur Revenue Circle in Lakhimpur district, Assam, for approximately 80 lakhs, without attaining my no objection certificate and from all other patadars of our family. So they submitted a fake NOC with force signature to execute the same deed. So my lord, this is the allegation. Now my lord, the concerned patta is 37 and the dag is 140 and my lord 243. So my lord, I have already annexed the Jamabandi of patta number 37, my lord.
Dag is
Dag is my lord 140 and 243. Now Lossi may kindly come to page 22. Now, my lord, the informant is my lord, informant is my relative, my lord. My lord, she is the, my lord, younger sister of my grandfather. Now, after the expiry of my father, my lord, I have inherited the land, which is, my lord, which is the share of my father in, my lord, patta number 37. So, my lord, kindly see annexure to page 22. So, my lord, kindly see, my lord, patta number 37 here. And the first name, my lord, Abdul Latif Borwa. My lord, he is the, my lord, my great grandfather. So, kindly see, my lord, in this patta number 37, there are several darks are there, my lord, 105, 113, 117, 118, 138, 139, 14, 140, and my lord, 147, 160, 117, 175, 190. So here, my lord, 243 and 2, my lord,
the petitioner's name is there.
yes, my lord, I'll show you that.
IB Borwa.
Yes. Now, my lord, kindly see, IB Borwa name is, my lord, mentioned in page 24, my lord.
Yeah, and serial number 20.
24. Now, my lord, her name is there, my lord, and her share of land is there. Lossi may kindly come to, my lord, page, my lord, page 30, my lord. My lord, second paragraph of the remark column, my lord.
Page 30.
30. My lord, page 30, second paragraph, my lord. চক্রবিক্রয় ইমান তারিখৰ নামজাৰি নম্বৰ স্বয়ংস হুকুম মৰ্মে 14 নং ডাগৰ মাটি উত্তৰাধিক কৃতে শ্ৰী আব্দুল লতিফ বৰুৱাৰ হস্তলত স্বয়ংস মেলত আইবি বৰুৱাৰ নেম ইজ দিয়া মেল ইন দ্য মিডল of this paragraph, my lord.
Last paragraph.
Yes.
Remarks column.
Remarks, my lord. Kindly see paragraph number second.
Namzari Param. Registration.
So in that number 14, my lord, IB Borua's name is there. Page number 30, my lord. Second paragraph. Even, my lord, her name is also,
Dark
my lord,
number 40.
14, 1-4. And, my lord, even in that number 190, in page 32. Page 32, my lord.
Yeah, the petitioner's name is not there.
Yes,
He's
yes,
not
my
a
petitioner's
shareholder.
name is there, my lord. I'll show you, my lord.
He's not a.
Now, petitioner name is, my lord, Lossi may kindly come to this. I'll show you the petitioner's name. My lord, then Lossi may kindly come to page 61. My lord, page 61. Page 61, my lord. My lord, serial number 345. Mohammed Imranul Latif Borwa, Mito Daudul Latif Borwa. He is the, my lord, petitioner. Now, my lord, kindly see his mutation, my lord.
He's also a shareholder.
Yes,
The entire land.
entire land. Now, my lord, entire line, what happened? The pattern number 37, my lord. Here it contains almost 20 tags, my lord. And between them, my lord, shareholder already land has divided. Now, I am, my lord, inherited my father's share. Now, lordship may kindly see page 103. 103, my lord. This is concerned to 243 draft, my lord, which is mentioned in the FIR. Page 103, my lord. Remarks column last para, my lord. Soprobiko, Iman Tariko, Namjari Nong Iman Mote, 243 নং ডাগর মাতে উত্তরাধিকারী সূত্রে দাউদুল লতিফ বড়ুয়ার সহস্থলত ইমরানুল লতিফ বড়ুয়া. He is the petitioner, my lord. And my lord, regarding 140 da, lordship may kindly 105 page. 105. Second para, my lord. Was you got it, man? Yes, 105 second para. Saprobika, Iman number Hukumote, tag number 142, Uttradek Utresi, Daudul, Borua's Tholot, Imranul Lati Porua. Now, my lord, in these two tags, 140 and 243, nowhere the name of the informant is mentioned, my lord. And where the name of the informant is mentioned, my lord, my name is not there. So it is very clear, my lord, I am selling my share of land, my lord, from tag number 140 and 243. Not his, her land, my lord. And her lane is already mentioned in dark number 19, dark number 17, 190. And dark number, pattern number 37 is a big pattern, my lord. It contains almost 20 darks. And now, my lord, kindly see in from this Avandi, my lord, we can see that so many shareholders has already sold their land to some other person, my lord. And my lord, I have registered this sale deed, my lord, by obtaining the my lord, NOC from the concerned revenue authority.
There is no patta has not been separated.
No separate, split, right? Yeah.
The thing is that, see, in my opinion, I may be wrong, but the first part is, it's an indication of a civil dispute that the co-share has not, but the second part, gives a criminal element that her fake NOC and four signatures.
No, no,
That's what she has said.
she is stated, my lord, in the FIR.
That fake NOC, four signatures.
My lord, kindly see.
That means her NOC,
My-
alleged, that see her NOC has been shown to fulfill the conditions of the sale perhaps. And that's a fake document. That part creates problem for you. That part
No,
creates.
my lord, kindly see, already NOC is there, my lord, issued by the revenue authority. And my lord, regarding my lord, sale of my part of land, which is my lord, covered by tag number 114, 243, my lord, her NOC is not required. Because her name is mentioned in separate tag.
There are elements of civil dispute.
Yes, my lord,
One aspect
my lord,
of-
if there is any
But
dispute, my
this,
lord,
one element of criminal liability has also been revealed by her allegations. So of course, we'll call for the case there, but I don't know whether it will be proper to give interim.
my lord, I am ready, my lord, I am ready to, my lord, appear before that, my lord, I hope, my lord, kindly see. My lord, kindly see. No, my lord, kindly see, my lord. In the Jamamandi, my lord, already, my lord, co-sharer has already sold their part, my lord, to some other person, my lord, their name is not reflected. And if that is the case, that I have, my lord, forcefully, my lord, mutated my name, in that case, my lord, she should file a case before the revenue authority. But that was not done. And my lord, other shareholders have not filed any FIR against me, my lord. And this dark, my lord, 140 and 240 is, my lord, exclusively in my name. It is granted mutation by the revenue authority. So, my lord, I may be protected and ready to appear before the IO, my lord. And let the CD come, my lord.
No, that's why I said. That gives. And even if.
My lord,
it should be before vacation.
No, my lord, my lord, my submission is, my lord, see, my lord, can you see? If in the mutation, my lord, in the mutation order, whether her name is present or not in the tab number 142, 43. If her name is present, in that case only it is required for her NOC, my lord. Otherwise not. My lord, kindly see in 140 and 243, my sister's names are there. Not her name is there, my lord.
It is definitely.
So her NOC is not required, my lord.
Part of it is civil, no doubt. That is for sure.
So my prayers, let me protect it, I will appear before the IO, my lord. They will clear all the thing.
But other aspect is a subject of.
My lord, that is a mere allegation, my lord, just to harass me.
Yeah, it is an allegation.
My lord, this is an allegation, my lord. That's why I'm saying, my lord, this is the mere allegation just to harass me, my lord.
So.
Last year is already mentioned in different ducts.
The petitioner herein, namely Imran, Imranul Latif Borwa, son of
Daudul
Daudul Latif Borwa, seeking anticipatory bail under 483 ANSS in connection with North Lakshmipur case number 265/25 under section 12. The FIR dated 5 8 3/37/2020. 37/2025 has been lodged by one IB Borrower, stated to be a relative of the petitioner. In the FIR, the informant has alleged that the present petitioner, accused petitioner, connivance with one named land broker, possibly and another revenue official, that illegally sold their land, 3 kathas within packet patta number 37 and bag number 140, and another 1 katha within brackets patta number 37, bag number 243, for an amount of ₹80 lakhs without obtaining her NOC and from other pattadars in the family. It is also alleged that the petitioner and others, for the purpose of the sale, submitted a fake NOC with 4 signatures to execute the sale deed. The learned counsel submits that he may be given interim protection for recording his statement for the IO. The learned counsel has taken the court through a series of revenue documents, a series of copies of revenue documents annexed to the bail petition, and has contended that both the petitioner and the informant are sharers of the ancestral land, and that the land, which was the subject matter of, allegedly a subject matter of the sale, falls in a different dump, and for which NOC of the informant is not necessary. This further submitted that the allegation of the petitioner forging an NOC and signatures is simply false. SH Bora learned additional PP submits that the allegation about forgery of signature and NOC, apart from giving rise to criminal liability, is a serious matter, and at this stage, prayer for interim may not be possible. Call for the case diary of so-and-so police station.
My lord, there may be prejudice to petitioner, my lord. So kindly see, it is very clear in that number 40 and 243, my lord.
No,
Where is-
my
which
statement, her submission.
Oh,
Her
okay, my lord.
her submission, I'm not. Her submission. Prosecution, that is what she has indicated. First of all. I find force in the contention of the prosecution that the allegation of submitting fake NOC with 4 signatures is true, is undoubtedly a serious matter. However, upon perusing the relevant revenue documents annexed to the bail petition and been taken through some of them, prima facie, it appears that the informant and the accused petitioners are indeed members of the larger extended family, having some inherited common land. First of all, whether the allegation of forced NOC is true or not, it would be a matter of investigation. But some aspects of the materials shown by the petitioner side undoubtedly indicates the civil aspect of the dispute as well. Therefore, at this stage, petitioner can be allowed to record his statement before the investigating officer in some interim protection. Therefore, in the interim, in the event of so and so, number one, he shall cooperate with the investigation or to appear before the IO and make himself available for examination, along with all documents that he may like to submit before the IO in support of his case. Number three, he shall not harass or intimidate the informant or our family. Number three, he shall not hamper or tamper with evidence, violation of the bail conditions and until cancellation of the bail. So we can take it up before vacation, 25th, if possible, or not possible. 25th, you can take a chance. Well, 25, this on 25/9/2025.
Obliged, ma'am.
After vacation, the interim has been granted. After vacation. The list after vacation on 15/10.
Yes.
Mile.
I do.
Obliged.
May I please your lordship.
No more than this.
In this case, lordship, in as much as 5 persons are named in the FIR, lordship, page number 16 is the FIR. Before that, lordship may kindly come to page number 18. Last part, received by so and so dated 22/2/2022. This FIR was lost on 22nd of February, lordship. Now,
As a zero FIR.
yes, lordship. Now, lordship, may kindly come
Can't
to
go
page number
police station.
16.
Okay.
16 is the FIR, lordship, and the accused number 1 and accused number 4, they have been arrested. They are in custody. Accused number 1's bail application is fixed on 22nd.
Amzad Ali and Upaludin,
Overlook.
they are arrested.
They are arrested. Amjad Ali's bail application is fixed on Port City, lordship, on 22nd of this month. And the name of the present petitioner is there only because of the reason that the present petitioner is the wife of the accused number 1. And lordship, the allegation was to show that lordship, the alleged incident was occurred on 10/1/2025. At the very first paragraph, lordship, with reference to the subject cited above.
Why don't you read the?
Yes, lordship, page number 16.
Can you read it?
May I read it, lordship?
What?
With reference to the subject cited above, on 10/1/2025, the above mentioned accused persons hired my four-wheeler vehicle on the pretext of taking said vehicle at a municipality in Guwahati. After reaching Guwahati, the above mentioned accused number 1, 2, and 3 is the present petitioner. In connivance with accused number 5, by threatening me, has kidnapped me in a dramatic way along with my vehicle. After traveling for about 14 hours, when I asked where we are going, then the accused number 5 at the instigation of accused number 1, 2, 3, and 4 stopped the vehicle and snatched the key of the vehicle from me and tied up me with the seat of the vehicle, and he started to drive the vehicle and put me to the vehicle at an unknown place. On the next day, I got to know that the place where they had kept me is Manipur, and from a reliable source, I could come to learn that the accused 5 owe money to the tune of 7 to 10 lakhs from accused number 1, 2, 3, and 4. Till the amount is not realized, I along with the vehicle would not be released, and they would also try to kill me. But very tactfully, I somehow managed to escape from that place and took shelter at the residence of so and so. I stayed 2 days at the residence of Blessed. The Blessed tried to rescue my vehicle, but failed. Thereafter, on 3/2/2025, the Blessed took me to so arranged my departure towards them. This is the allegation, lordship. The FIR was lost, lordship, almost after a delay of lordship 1 year and 1 month and 12 days, lordship. The LS
No, 10/1/25.
10/1/25, and then FIR was lost on 22/2/2000.
After up to 1.5 months.
1.5 months, 1 month, 12 days. And the person lordship, the accused number one is already
Yes, she was. See, according to her, she was kidnapped and she
E,
could escape only on 3/2.
E lordship. The informant is a male lordship. And the section lordship which has been under which the case is registered is 6187. Perhaps lordship 87 would not be applicable. That is kidnapping of women lordship. As because lordship, the informant is a male person here. 109 has two part lordship. The first part says that lordship if it is with her and without her. If it is without her lordship, then 7 years. And lordship 336, 3 lordship, 1 second lordship, it is up to 7 years. I have not received any notice as of now, lordship. And may appear for interim lordship and other cases are fixed on 22nd already. Okay, stay. And
On 22nd.
that can also be done. I'm paying for interim
22nd of
this
month.
Yes.
I think it's nature, see the nature of the allegations.
That
Named
will-
also. Only a few days later.
Yes, yes,
That is-
yes, lordship.
And of a serious nature. Very,
Medical report also may be
not
called
many
for.
days is heard.
Emma.
M. Ahmed and Ritik Goswami. Call for the case diary of Navapera, PS case number 24 of 2024. They submitted that similar matters, matters arising out of the other matters, other matters arising out of the same FIR. Some other matters.
BA number 3034.
Are fixed on 22/9. This is the matter on 22/9/2025. Should I give the other connected dates? Along with
BA number 3034/24.
only one. 303,
3034.
3034 of 2020.
If may kindly call for the medical report also, lordship.
Call for case diary along with medical
Medical.
report if any.
Yes.
Yeah.
I got it. Yeah, please. But this is the three errors been application. FR kindly come to page 9 also. Merit lordship. Yes. Respectful humble submission is that today morning at around 11:30 AM, the below named accused person came to my CSP at Rathiadaha market for depositing an amount of rupees 10,000. On checking, 5 numbers of notes of rupees 500 were detected to be fake. And accordingly, I did not deposit the notes and returned her back. After returning from my shop, the accused person tried to use the aforesaid fake notes in a nearby shop. And then the people of the market came to know about the fake notes, detained her, and being asked, she replied that she brought the fake notes from one Mokbul Hassan. This is the present petitioner in this instance petition, son of so-and-so. Thereafter, the matter was informed to the Golobganj police station, and accordingly, the accused was taken to police station along with the said fake notes. It is to be mentioned that the accused person also tried to do the same thing in the earlier hours. So should have the basic allegation against the lady. Initially, though, it may presume that he had no knowledge about the fake news. Later on, when it was detected by the CSP holder, she then tried to use the same by knowing it's fake news. So main allegation attacked to her, and she, on her statement that she brought from me, lordship, this is Mokbul Hussain. And lordship, I have, my cases I have narrated in para number 4, page 3, lordship.
Para number
3, lordship. 4. Admittedly, lordship, the FMM accused number 1 I had taken, yes.
Okay.
Yes, Lordship, the lady, Lordship, she was arrested on 25/7/2025, and thereafter she has been released on bail on 7/8/2025, only after judicial custody of 12 days. I have the order to the
Arnett Court below.
court, yes. Abdul- Paragraph 5 is the consideration. Only 5 number of notes were detected. The petitioner may not have knowledge of related to legal performance. That this lordship kindly takes for the procedure in the meantime, he will be given one opportunity to record this system. Since the private authority.
This order was passed after perusal of case diary. We do not know not much has been narrated. It is more centric to the lady
Yes.
who was seeking bail.
Yes.
But regarding this person's,
But as per the her state
No, lordship, the rejection order.
that is her statement. Only, who is also accused.
The implication of whether he is also not after whether the case
The notes, lordship, is lordship, 5 notes only, lordship.
No, not the counterfeit. I mean, as you rightly said in the beginning,
Yes.
it is a conscious position.
conscious of her.
That a person has to know. Unknowingly, anybody can
Yes.
come in touch with counterfeit.
Yes,
Knowing it
lordship,
and then trying to use it, that's the offense.
yes, knowledge.
So that, if
knowledge.
we go by the FIR, the incriminating material is a statement of Goik.
Wait, yes.
From one point of view, he can be given a chance also. But if you
Yes.
just look at it from the point of view of counterfeit currency, then it's a serious offense.
Benefit of-
crime.
Benefit of doubt.
Serious offenses.
Lordship, because only our statement of, I have been implicated.
But if okay, they also.
Now, is it Ahmed? Your
Yes.
Is it Ahmed?
Yes.
Ahmed counsel for the petitioner. Accused petitioner seeking anticipatory bail under 482 BNSS in connection with Gologons PS case number 188 of 25 under section 179 180 BNS. The Ezahar is dated. The date of the Ezahar.
Yes, lordship, it is 25/7, lordship. It was not reflected in the lordship.
25/7. Ezahar, the FIR is dated 25/7. It is alleged in the FIR that allegations. The case of the petitioner at this stage is that he had given some money to loan to the co-accused. The co-accused was Chani Khatun. And She returned the same to him. And thereafter, when she was trying to purchase something from one customer service point, some of the 5 of the currency notes were found to be fake, and she was apprehended. The learned counsel has submitted before this court order dated 7/8/2025, passed by learned additional session judge, Rubrik, granting regular bail to the female accused named above. The involvement or otherwise also hurt Digdi Goswami learned additional people. 6, the case diary while opposing the prayer for interim protection made by the petition. Any offense pertaining to fake currency is undoubtedly a serious matter. Though forming implicated and prosecuted for such an offense, the concerned person has to be in possession or want to be dealing with such currency, knowing it to be counterfeit. In other words, conscious possession. Going by the case diary, going by the FIR, prima facie, the only incriminating material against the present petitioner, who's named in the FIR, is that that the other co-accused was granted bail by the learned court below. Replied upon being confronted at the time of the incident that she brought the fake notes from the present accused petition. Since the said lady is herself an accused in the case, alleged to be handling fake currency. Therefore, at this stage, her statement, her supposed statement on these lines against the present petitioner has to be seen with a critical eye. Therefore, while calling for the case, the petitioner at this stage should be given an opportunity to record his version of events. Call for the case diary of Golokwan's PS case number 188 of 24. However, in the interim event of arrest of the petitioner, 25,001 the commissioner he shall appear before the eye and make himself available for examination. Otherwise, cooperate with the investigation. Not hamper or tamper with evidence. Semicolon, not cause any harassment or harm to the informant side, as well as to the lady co-accused. Fixed on before vacation or after that? 1910-25. List up to the vacation of 1910-2025.
Message from the no cases pending against the petition.
Counsel is not come, should we wait?
Well, this matter may kindly be taken along with item number 49, because against the same FIR, That case has been also filed. In that case, CD has been called now. So 49 may be taken up
Now or later when it comes?
later.
Okay.
I pray with the lordship just to accommodate. Can it be possible to take up the same matter, my lord?
No, which method? This one. Can I claim?
Same matter.
Connect.
But
You also there in one. There are three matters.
it's very clear, my lord.
I'll take up.
It takes up right now, my lord. It will be convenient for both of us, my lord.
Okay, right now.
Right now, my lord.
No, it's the subject to.
I think 60.
You want to do it later? So you want to do it later?
I can do, but CD is the same. So it will be better to take up all the three matters together. So one argument will be sufficient for.
I'm for the only one accused, my lord.
Then make the argument.
Yes, no problem.
And then you are, if necessary, you can add some after something. Okay.
So my item number is 52, my lord.
Yeah, it's in your lordship.
Okay, someone from BC also. Just a minute. I'm told, madam, that your BC is the next item, not this one. So kindly hold, you can log out. Item number, let me.
My lord, my item number is 52.
52 and then
Then one person, my lord.
you are
49. Mine is
49.
49. 6.
So now I take up 52.
Yes, my lord. I am for one Mubashir Ahmed, my lord. My lord, the FIR itself indicated, my lord, from 1 to 15, they were the family members or they were present at the place of occurrence, my lord. From 1 to 15, my lord. Admittedly, rest are not present at the place of occurrence, my lord. And in the 24% altogether named, my lord. Lordship, kindly take up the vernacular, my lord, page 23. নিবেদন এই যে কিছুদিন পূর্বের পৰা 1 2 3 4 5 6 7 8 9 10 11 12 13 14 আসামীৰ পৰিয়ালৰ লগত এজাহাৰকাৰী পৰিয়ালৰ পূৰ্বতে মাটি কিনি লোৱা এতিয়া ইমান লেচা মাটিক লৈ বিবাদ চলি আছিল যোৱা ইমান তাৰিখে 15 জন আসামীৰ লগত 15 নম্বৰ আসামী এজাহাৰকাৰী পৰিয়ালৰ দখলত থকা মাটি বলপূৰ্বকভাৱে বেদখল কৰাৰ উদ্দেশ্যে ট্ৰেক্টৰ লগাই হাল মাৰিব যোৱাত এজাহাৰকাৰী ককাই সাইদুল ইছলামে ওচৰ চুবুৰীয়া মানুহ লৈ বাধা দি হাল মৰা বন্ধ কৰিছিল on 16 days nothing had happened যাৰ ফলত উভয় পক্ষৰ মাজত তৰ্কাতৰ্কি বিতৰ্ক হৈছিল উক্ত আখেজৰ বশৱৰ্তী হৈ আসামীগণে এজাহাৰকাৰী পৰিয়ালৰ লোকক প্ৰাণে হত্যা কৰিব বুলি ভাবুকি দিছিল উক্ত ঘটনাৰ পিছত উক্ত ঘটনাৰ বিষয়ে আসামীগণে 16-17 আসামীৰ লগত আলোচনা কৰি গোপন বৈঠকক বাকী 18-24 নং আসামীক মাতি এজাহাৰকাৰী পৰিয়ালৰ লোকক হত্যা কৰাৰ ষড়যন্ত্ৰমূলক পৰিকল্পনা ৰচনা কৰিছিল 16-17 আসামীৰ হুকুম মতে 1 পৰা 15 নং আসামী 17-8-25 তাৰিখে ৰাতিপুৱা 9 মান বজাত পুনৰ উক্ত মাটিত ট্ৰেক্টৰ লৈ ট্ৰেক্টৰৰ হাল মাৰিব যায় তেতিয়া এজাহাৰকাৰী ককাই শহীদুল ইছলামৰ লগত থকা দুজন ক্ৰমে তৈয়ব আলী আৰু শাহজাহান বাদশ্বাহে বাধা কৰাত উক্ত 15 জন আসামীয়ে হাতত দা লাঠি ডেগাৰ উঠা ৰাতিৰে প্ৰাণে হত্যাৰ উদ্দেশ্যে এজাহাৰকাৰী ককাই তাৰ বাকী দুজন লোককো আক্ৰমণ কৰে উক্ত ঘটনাত এজাহাৰকাৰী ককাইকে সাইদুল ইছলামক ঘটনাস্থলীতে মৃত্যু হয় তৈয়ব আলী গুৰুতৰ জখম হোৱা এটিকে উন্নত চিকিৎসাৰ বাবে গুৱাহাটীলৈ প্ৰেৰণ কৰা হয় উক্ত মৃত্যু সাইদুল ইছলাম মাটিত পেলাই ইয়াছিন আলী ইলিয়াছ আলীয়ে শীতল মস্তিষ্কেৰে ডেগাৰে দুই মূৰ ভৰিৰ শিৰা কালি So my lord, specific allegation against actually Yasin Ali and Ilyas Ali. Accused number, my lord, 1 and accused number 5.
1 and 5.
1 and 5.
Specific allegation.
Yes, Ibrahim Ali, Yeah, act attributed specifically, my lord. Ibrahim Ali Kuthar di khap mari mor dufal kori diye. He is accused number 3, my lord. They are already arrested, my lord. Yasine Degar di Gopia hat kati di. Yasin is accused number 1. Baki ma 2, 3, 4, 5, 6 মান ইমান নাম 15 নং আসামি উক্ত আছে ইয়াসিন আলী ইলিয়াস হুছেইনৰ লগত সহযোগ কৰি হাতত জাহাজ আছিল এজুকৈ ককায়েক সাইদুল ইছলাম হত্যা কৰাত সহায় কৰিছিল উক্ত আসামিগণে অৰ্থাৎ 1 পৰা 15 লৈকে তৈয়ব আলী আৰু শাহজাহান বাদশাহকো প্ৰাণে হত্যা কৰাৰ উদ্দেশ্যে হাতত দা দেগা আদি লৈ তৈয়ব আলীক ডিঙিত হত্যা কৰি জখম কৰা আৰু শাহজাহান বাদশাহ দেগাৰে হানি হত্যা কৰিব বিচাৰে যদিও দৌৰি গৈ এজাহাৰকাৰী ঘৰত সোমাই প্ৰাণ ৰক্ষা কৰে প্ৰকাশ থাকে 1 পৰা 15 নং আসামিকে উক্ত সংগঠিত কৰি 17 নং আসামি ঘৰত আশ্ৰয় লৈছে বুলি মই পৰস্পৰে জানিব পাৰিছো that's one of the what happened my lord I am the member of the Jila Parishad my lord in this case my lord and there is an enmity between me and the informant because informant initially he wanted to contest the last election which has been later on he was not given the ticket and I was given the ticket and I become the successful candidate. Yes, that's so he has just implicated me in this case and my specific information that on that day I was not there. I was 20 kilometers away from the place of occurrence on that day. 30 kilometers away, my lord, and I reside in a different place, my lord. So hopefully, my lord, case diary will reveal. Apparently, I was not there, my lord. And there is no question of any, my lord, conspiracy to that effect also.
This one is only for Mupaswar,
Only for
the Jila Parishad member.
Okay. So my learned will definitely from the case that you'll say, man, whether anyway I'm my information. I was in a different meeting, my lord, in 30 kilometers, in 3 different places on that particular day. At Jagi Road and Devkhal and nearby place.
The other base,
Yes.
like to some 49 mile. 49, 2 brothers, my lord. One is 65 years and other is my lord 57 years.
Accused number 2 and 10.
2 and 10. They are also, nobody has implicated them, except only my lord, name is there. Then just my learned friend, Mr. Anshuman Bhai, as allegation against 1, 3 and 5, already arrested. And my case of paragraph 9, we are also not present, my lord. Family member land dispute between the family members of that is the allegation. And these persons are also not present. So on 2 counts, my lord, one thing is, my lord, there are no specific allegation except in the name, my lord. And other one is, my lord, they are not present in the place of occurrence at that time. So indeed, my lord, age factor one is 65 years and 57 years.
Yasin Ali is arrested.
Yes, already arrested.
Elias,
Already, my lord, arrested, your lordship will find accused number 1, 3, 4 and 5. Your lordship
arrested.
1, 3, 4 and 5 arrested. Against them, a spray allegation is there. I think your lordship got the point. So for the petitioner, custody indagation is not required.
You want to make it now?
Well, so far, item number 60 is concerned. I am the accused number, kindly see page 17. Page 17. this 16, 16, 19, 20, 21, 23. So these 5 persons.
16, just,
Yes. 16,
just take it again.
page 17 can list.
From the Ejaha only, I have to mark.
Yes,
Accused number?
accused number 16.
Rafiqul. 16.
Then Jared, 19. Then Ilyas Hussain, 20. Rafiqul Islam, 21. And Fazil Haq, 23. So, my lord, I think their main accused have been only arrested. And we are simply named because we are known to the principal accused person.
Prosecution will make your submission, then I will fix it for delivery of order tomorrow. So I have to study many.
A person was totally killed by using sharp weapons. By more than 20 people, I think. And as per the postmortem report, the cause of death is due to massive hemorrhage and shock leading cardiorespiratory failure and death as a result of multiple injuries sustained by the person during life. And several witnesses were examined. Because they have seven persons were present there, also they cannot identify by name some of them, and some of them were they might be identified by name. So main allegations against 4 to 5 persons of it. And going to the statement of the witnesses was it. In the item number 52, Upaswar of it. So this is concerned, they have to say anything against the Upaswar. And in item number 49, Lord Chief, the witnesses are including both the petitioners. They are present at the place of Ohio, and they have taken by the question. And in the item number 60, Lord Chief.
Okay.
Item number 60, this is included, so number 2 and 3, Ziarul Haq and Ilyas. Rest of other thing. Specifically, we take it. So let's see, I have available.
I'll go through it properly.
Oblige.
It's necessary because there are many people. Just
Oblige.
carefully see.
Our prison does not mean that we have participated.
Very risky, very risky.
Our participation is 0.
Very risky.
Welcome. I'm obliged for the,
Application and exoneration is risky in group. But I'll study carefully. Third, respect counsel, senior counsel. State. Third, additional PP person. Case diary has been briefly for the fixed to delivery to go outside.
well, I'm obliged for the accommodation.
Action blanks.
Your lordship,
Yes. This is the admission.
yes, your lordship.
Motion. Criminal petition.
Sir, yes, yes, sir,
that matter, lordship,
this was previously the writ
Writ
petition.
petition criminal that was transferred to criminal petition.
Oh, I see. Criminal petition.
Yes, your lordship.
Just let me update myself. Last order. Just give me 1 minute.
Yes, sir.
Okay, fine. The prayer is basically quashing, right? Quashing of the proceeding.
Yes, your lordship. Quashing the
are,
proceeding or
I'll hear-
stay,
You are for the petition?
Yes, Your Honor. Yes, Your Lordship, and from the
You are
petition of
appearing
one
for
and two.
Delhi, right? I remember.
Yes, Your Lordship.
Okay, so go ahead.
So, Your Lordship, previously I mentioned the legal issue and the ground where the magistrate failed to comply section 223 subsection 1 of BNSS mandating examination on oath of and recording of statement of the complaining and witness before issuing the notice to the accused. So basically, to this honorable court, I am challenging the order dated 16/6/2025 and 28/7/2025 of the judicial magistrate.
Okay,
So your lordship, basically, in the merits, the petitioner number 1, who is Mandeep Fokla, Mrs. Mandeep Fokela, is a lawful owner of the immovable property in Golaghat town with a registered will dated 19/6/2024 by her late father, Mr. Bhupender Singh Anand. And the petitioner number 2, Mr. Vikas Dhopar, is an independent law-abiding citizen with no interest in the disputed property and also is a friend of petitioner number 1's husband who has been wrongly implicated in this criminal complaint. Pe- Petition number 2 has no relation with the property, no relationship with Varun Deep Singh. He was just there because petitioner number 1, Mandeep Fogla, husband, was sick. So her husband requested Mr. Vikas Dhupar. So he was with Mandeep, petition number 1. On 27/5/2025, Your Lordship, respondent number 2, who is complaining in the lower court, Mr. Varun Deep Singh, he allegedly transfers on the petitioner number 1 property, which is registered on her will.
okay.
And your petition number 1, via email, complained to the police authorities to FIR, requesting for registration of an FIR against Varun Deep Singh. But no action has been taken from the police side. Am I audible to your lordship?
Yes, I am hearing. You're audible. I'm trying to grasp the matter. Go ahead.
Actually, there is this.
Thereafter, it was.
Actually, there is this mentioned network issue. Yes, your lordship. Your lordship, on 13/6/2025, petitioner number 1, Mrs. Mandeep Fokela, with the proof of appeared before the duty magistrate in the Golaghat station and showed that she has been given this property by her late father. In the presence of duty magistrate, she submitted this. And still on 23rd July, she received a notice in the CR case 85/25, where the section 223 pre-cognizance safeguard wasn't compliance.
Main point is that, right? Precognizance hearing.
Yes, your lordship, I am here in this honorable court just to quash the matter in the lower court because the main provision of 223 subsection 1 is not compliant.
Violation
I
of
have all the
223(1).
relevant documents. Yes, your lordship.
Can you tell me the page number of the complaint? Criminal petition.
68, lordship. That would be the 68.
Okay, I got it. Okay, anything, the local council, like you said?
Lordship, it is totally a civil dispute. Like a civil dispute of will, Lordship, that is probate case is already pending before
No,
the.
that's true, but the immediate issue for us, I think, is the violation of.
Yes, yes, Lordship.
223(1) proviso,
Yes, Lordship.
right?
Yes, your lordship. Yes, your lordship. Yes, 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 your
Which is a
lordship.
new provision now. No cognizance shall be
Yes,
taken
your
without
lordship.
giving an opportunity of being heard. The complaint case.
Yes, your lordship.
Lordship,
I'm
next
obliged here.
Next bit of the CRP is on 20. That's why Lordship, we are praying for stay of the CRP.
No hearing whatsoever was given or not at all. Complete
Sorry,
non-compliance.
Yes, your two.
No hearing was provided, Lordship.
No hearing. at all. This is a Karnataka High Court judgment on that issue.
Yes, Lordship. And 10-11 is the relevant Lordship.
Of course, the opportunity of being heard can be interpreted in multiple ways also. Complete non-compliance would be easy to decipher. There's no compliance. Otherwise, the opportunity to be heard means issue notice, then hearing can be through counsel also. Why not
Lordship,
necessarily the accused.
In now, Lordship, without recording the
Yes, I'm so sorry, lordship. There's been some new network issue.
No, no.
without recording examination the complaint, Lordship, normally magistrate doesn't issue notice also, Lordship. Inquiry. 202, Lordship, again. Inquiry, that provision has not been done. Lordship. And if
Your
that's
lordship,
already,
am I audible?
In the audit, your audit, I get it.
Yes, your lordship, in the Karnataka High Court, which I mentioned earlier, Sri Basangoda R. Patil versus Shivnanda, where it is also mentioned, the Supreme Court set aside the order of judicial magistrate and the High Court and caused the proceedings that a complaint is present before the magistrate under section 223 of the BNSS. On presentation of the complaint, it would be the duty of magistrate or the concerned court to examine the complainant on oath, which would be his own statement and extent of such examination should be reduced into writing. The question of taking of cognizance would not be arise in this junction. The measure issue a notice to the accused is given an opportunity of being heard. Therefore, notice shall be issued to the accused at the stage after hearing the accused. A detailed explanatory is your honor that examined complainant and witness record statement issue notice with those paper to accused for your hearing. Only then you can take any cognizance and proceed. The pre-cognizance requirement has not been complied by the lower court. That is why my prayer is to purge the entire proceeding, your lordship.
Yes. Okay. What's your private? You have to give a notice. Yes, Lordship. Yeah, at this stage you have to give a notice. And interim prayer, I will see prima facie Mr.
Risha Sharma.
Richard Sharma, who was appeared to an online mode from Delhi, assisted by.
So, your lordship, I have something to say.
Yes.
On the last date order, there is this error. Instead of Bhupender Singh Anand, it is written Bhupender Singh Ahmed. Kindly rectify that, and my spelling is Richa Sharma, Sharna. It was also error, your lordship.
There are no names, I think. Just correct it if there is an error. There's no such
Okay, your
name.
lordship.
There's no such name here. There's no name here in the last one. Correct it anyway. You give a cheat. Yes, sir. Correct.
I'll provide the
Or maybe in the other file. Okay. So heard also. Here is the last order dated 10/9/2025. The case was initially filed and registered as a repetition criminal. However, upon finding by the court that the essential prayer is for quashing of proceedings, criminal proceedings in exercise of powers under 528 BNSS 2023. It was directed to be re-registered as criminal petition and accordingly done so. The learned counsel for the petition appears to online notes from them, assisted by the learned local counsel. Complaint dated 2025 was filed by complainant Varundeep Singh before the court of the learned CJM Golaghat. The two petitioners herein were pleaded as accused persons. On the basis of the complaint, CR case number 85 of 2025 was registered under sections 68B of the BNS 2023. The petitioner is agreed by the subsequent orders dated 16/6/2025 and 28/7/2025. Two orders are for these are the cognizance orders, right?
It's for the hearing that order dated 28/7/25. The judicial magistrate asked.
28/7/25, right? The order taking cognizance order 16/6/25 and
Sir,
28/7/25.
the order is, gee, both the orders without safeguard she.
Whereby the learned magistrate was pleased to take cognizance and issue summoning order to the petitioner's hearing as accused. The primary contention of the petitioners is that the order of cognizance was passed without complying with the provisions of section 223 of section 1 BNS 2023. Impugned order is at which page?
Lordship, page 14.
No?
Page 14.
14.
14, Lordship.
1/4.
1/14, your lordship. Yes, your lordship.
And 28/7 order, which is the 28/7 order?
Lordship, page 79. And at page 79, Lordship, that part that no cognizance was taking without taking cognizance as mandated under 223, that was recorded, Lordship.
but this order does not indicate taking of cognizance.
No, Lordship, the learned magistrate
Your
has,
Lordship,
This
on
order-
16/6,
No,
When-
this order
when
is,
she,
on 20th, it was fixed for hearing you.
Your Lordship, once,
yes,
sir,
Lordship.
without examination, the complainant and recording, can the learned magistrate hear me? On 6/2025, she should have recorded the statement and the witness if there was any. Without complying, that is the whole point of, without recording any statement of the complainant and witness, how can she notice issue to me and how can she hear me first? Without doing that, without the pre-cognizance safeguard.
Okay, you may have a point actually. Then the hearing, if it is examination of the witness, according to you, first the complainant should be examined,
yes,
the
Lordship,
statements of
Yeah.
the witnesses, then notice to you,
yes.
then hear you
Yeah.
alone, right?
Yeah.
Yes,
The
Your Lordship.
complainant
Yes,
was
Your
already
Lordship.
heard.
And Lordship, this point in the middle, I'm reading Lordship. Perusal of the case record reveals that the instant case was filed on 16/6/25 and order to issue notice to opposite parties was passed without taking cognizance as mandated under the 223(1) of BNSS. Lordship, it was the clear mention in this order.
No, that will not be a taking cognizance because specifically the order has to mention that cognizance is hereby taken. Has to mention. This notice was to issued to you in compliance. The magistrate, after perusing these two orders, the magistrate is fully aware that according to the new provision, pre-cognizance hearing has to be given to the accused.
Yes,
Okay.
Lordship.
The magistrate was aware.
Yes.
So this notice
But,
to you
but Your
was not
Lordship,
was not a summoning order.
Yes, Lordship. But before that, the learned magistrate has to
in the
record the
Yeah, that
record the complainant. So version the complainant.
In the Karnataka High Court, it is clearly mentioned, Your Lordship,
no.
that the judicial
That's-
magistrate.
That's true. Before we go to citations, first we should be clear about the facts of this, right? Should be clear about the
Yes, Your
facts.
Lordship.
She was aware, the magistrate was not in ignorance of this provision. But your grievance is that before examining complainant, you were summoned, right? So anyway,
Yes, Your
we'll
Lordship.
examine it. Upon perusing the said orders dated 16/6/2025 and 28/7/2025, it is revealed that in compliance with the proviso to section 223 subsection 1 BNSS, the learned JMFC issued notice to the parties, to the opposite parties / accused, and on the next date, that is 28/7/2025, petitions were filed on behalf of the two accused persons, whereupon the learned JMFC held that they had received the notices sent in compliance with the said proviso. Full stop. Subsequently, in the said order, the learned JMFC was also pleased to fix the matter on 28th this act for hearing. What happened? Did you appear? No, you did not appear on this day. On this day, did you appear on 20th August?
No, Your Lordship.
No instructions.
I appeared before the whole order.
You appear?
The complainant was also not present. The complainant was
Okay.
also not present on that day.
Well, if
On
that
28
continues-
2025, the complainant was.
Yeah, if that continues, so eventually this 256 can be triggered anyway. Now, one of the contentions of the petitioner side is that the pre-cognizance hearing that has been stipulated in the BNSS with the new provision was sought to be resorted to before examination of the complainant and his witnesses. And therefore, the said exercise is procedurally erroneous and requires interference by this court. So stop. The relevant provision 223(1) is reproduced herein bill. First, at this stage, the petitioner said issue notice upon the sole respondent / complainant. Call for scan case report. Scan case report of CR number. So it's going to be given. In the given facts and the next date of hearing of the matter is stated to be on. Next date is. Next date?
20th September, Your Lordship. 20th
20th
September.
On 20th September 2025. Just, since this court has initiated the process of hearing the matter. Initiated the process of looking into the grievance of the petitioners on the basis of materials. Therefore, it is directed that till the next date of listing, further proceedings in CR case number so and so shall remain state. Let it remain safe. That's okay. We'll see.
Yes, Your Lordship. I'm grateful,
But
Your
it is,
Lordship.
initially, I had thought that it's a outright violation. No, that's not. She was aware. They have been trained also, and she was fully aware that this is that. Only thing is that you think the sequence is faulty. Yeah, it's true. But your grievance, now I understand more clear that your grievance was that sequence was faulty. First, you have to examine complainant witnesses, then you issue, then you hear the complaint, and then you decide about cognizance. And in any case, cognizance, we have to correct writing things. We have to correct. Cognizance has not it. Cognizance is not included. So this is actually not really a question of cognizance, right? So you submit this before the court and then it gets the records. All this can be first. It's made for like the learned counsel for the petitioner side has placed before a decision of the Honorable Decision of the Honorable Karnataka High Court rendered in the case of reported in 2024 SCC online. I'll go through this just in more detail. Case laws are still emerging. This point, whether the person can be from the statutory provision sequence, appears to be first you have to examine the complaint and then that appears to be the sequence. But suppose that is not done. Will it be a fatal infant? These case laws are still emerging. Provisions. We'll have to look. So I discuss. It's worth examining. So all from this report, so you take the steps. Yes, for sure. And date is to be list after the petition on any suggested date. There will be a last of the maybe first of all. 311. Okay, 311. The proceeding in the state. Proceeding in state till next date of listing. Like this. Yes. This was we sought a report.
Yes.
No FIR, no findings. Mr. Fukon. Earlier submitted. Additional direct was asked. Next page. First one thereof. Today it is submitted by the learned additional DP was submitted. Information has been provided. Written you received?
Yes, information.
Okay, information has been received from the concerned police station that no FIR been lodged against the present petition or any case registered against him in the said police station. It's not necessary. Therefore, the apprehension of arrest they would be baseless at this case. And the instant pre-arrest application is disposed of as non-maintenance. Okay. Also, CBI matter.
Yes.
Today we will close this. We commence.
Your lordship, it's already hard to
I've
make.
already heard, and actually, it was largely for the madam, it's for submission of some CD, and if necessary, some further solutions.
State that CD is required.
Yeah, I guess.
So what happened, your lordship, charge sheet has already been filed and the CD has filed in the court. So requisition has to go. Now court may not give the IO on the CD.
So he's in custody, right? Reasons.
Almost 2 years.
And one of the, I understand, that's a valid point, say, submitted in the court. But now court is in charge.
One requisition is required so that IO can be.
Because, bail, your bail contentions are based on this provisions, constitutional provisions.
Yes, ma'am.
Therefore, there should not be much delay on my part in decide this, whichever way. But we have no other option but to seek. So what do you think? Yes. Have to.
On Monday,
From here,
From here,
from
already
court.
accord. Period or
January.
take activities.
There was last order dated 11/9/2025. Was to, learned retainer council senior submits that has come to be known that in the meantime, charge sheet has been submitted by the IO and placed before the court. So therefore, we'll have to get a scan copy or the CD in origin.
CD in original means your lordship, otherwise ongoing scanning, it has to open each and every.
Yes,
page.
and I know this.
Get
I
this
know
one,
the CDs
Yes,
of NIH.
get this one.
There
So
can
let
be
it come in
different.
original. Somebody will.
Call for the
IO
case
will-
diary. Yeah, call for the case diary.
And the concerned IO will bring authority can be.
Call for the case diary and the charge sheet from the learned CBI court.
Sources have been annexed already. I've annexed it to you along with the petition.
Charge sheet I have also annexed. It's
It's not necessary.
not-
Charge sheet is not.
Charge sheet is not.
Oh, acha, fine.
It's other.
So, pursuant to charge sheet is submitted. And the case diary has been deposited before the court. It is in the court.
Yes.
It is in the Rehab.
Yeah, special that's all. Yeah. Both the learned council submit that copies of the charge sheet been annexed by both the sides. And so the same is not necessary. However, call for the case diary in original from the court of the learned special judge CBA.
Yes.
Please.
Yes. Actually, that's a special CBI and the others are additional CBI. Actually, the CBI will also do a matter of proportion. Civil judge, special judge, CBI and NI.
Will be the carrier here also. Appropriate for the meeting.
Yes. No, they have messenger, court will have messenger. Or through the IO.
IO's name is required, otherwise they are not going to hand over that seat. Either from the court, somebody will go
Yeah.
and bring. Then it is.
No, they have messengers. I regular, one boy is there. One boy is there. He comes. He comes here and bring. So we'll fix it on Monday.
Yes, ma'am.
Uh, Notice be sent immediately, like a registry. List on 22/9/2020 for case there and remaining hearing it. Post this.
Today's third time, my lord, putting on.
Yes, there is come. Not yet.
And today's third time, my lord, and my lord, behind the bar, my lord, 76 days, today, my lord. And during my lord, initially, my lord, I used to have 4 days in police custody. My lord, the FIR at this 9 months. Here in the FIR, it is stated, my lord, the ELT culprit, etc. are involved. I am reading, madam. With respect to the subject cited above, I have the honor to state that a team of traffic robbers have entered in my house after breaking grills, doors, etc. with so. All ornaments valued more than 35 lakhs and cash looted more than 21,000, etc. They threaten us by using sword, etc. nearby 1 hour. They have taken for whole home looting time briefing. They are from BLT culprits. Then, my lord, come to the forwarding report, my lord. What is the reason stated, my lord, by the petitioner were arrested, my lord, plus 18.
Just a minute. Mr. Gusam, which time? Bilasupa. When can we get it?
And well, both the accused persons are own brother, my lord.
Actually, the allegations are different.
BLT.
They are considered interim.
We are not
Very
BLT.
serious.
We are not belongs to BLT, my lord.
No. You presume to be innocent in any case. But the thing is that the allegations are very serious. For the trial, you are presumed to be innocent. Begins. But the allegations are of dacoity. But 22nd. Kindly convey that vacation is there, so
Then why I prayed for personal appearance of the IO, my lord, because my lord, my lord,
the case diary is stated to be not available to them. The learned counsel, Mr. Hussain has submitted that the petitioners, that the petitioner side is aggrieved by production or non-availability of the case diary over more than one date. Instead. The issue fresh reposition of the case diary, the IO is directed to positively send the case diary on or before the next year. List on 22/9/2025 for the case diary. It's have to send it. I'm not seeing any report that he has to give time and prepare. Seal it and send the same. Also.
publish.
Not received. It's called the part-time serious not building. Same kind of grievance. Yes, there is not a receipt. Same order I'll pass.
Same item, same day.
Issue fresh reposition, IO is directed to positively produce the case diary on or before the next. Second one, 22. 22. Small 22. Okay.
Serious not come, your lordship. The section is very serious, your lordship. Whether my involvement is there, your lordship. Whether my involvement was there, your lordship. I was not taken even into police custody, your lordship. Directly forward to your lordship, judicial custody, your lordship. Umbransu, your lordship.
I have made a prayer also, that's case bearing. But then I thought.
That's equal to 8. Your lordship.
Your Lordship, at the relevant time, Your Lordship, when the incident took place, Your Lordship, he was there in his office. He's the engineer with L&T, Your Lordship, construction, Your Lordship. It has been, Your Lordship, all the office is, Your Lordship, under CCTV camera surveillance, Your Lordship.
What
He
is
was,
the
his presence was there. Your Lordship. Huh? 103 is there.
Anyway, is there is not yet been received. So, issue fresh recognition for the case diary of Boomerang UPS case number 17 of PDP. I was directed to positively send the case diary on or for the next. When should we fix? Send it. 24.
23rd, can it be, Your Lordship?
Well, no, next week, no, notices come on. 23 9.
Oblige, Your Lordship.
But please, Your Lordship, my senior is on legs in another court. I may be taken at 2.
After second, no.
Are you here not to rejected this bill? Now he's in custody for last about 58 days. The offense is only under section minus 330. Maximum 336 subsection 3 is forgery for cheating, and it is maximum is up to 7 years. So it is as per section 187 of the BNSS is 60 days. Now we have already spent more than 58 days. Only 2 days left. And we not what happened? This bail application has been filed because the wife of the petitioner is suffering from certain mental illness because of the absence of the husband. And otherwise, other accused persons, this is relating to that matter take appointment later case. Your Lordship has already granted some bail to some similar situation.
It has been granted.
Yes.
Anyway, CDS notices. 20,000. Subsequent developments.
But this period of maximum period of probation is 60 days. It's almost over, Milord. As per section 187 of the BNSS, Milord, it is up to 7 years. One section only. That is 336 subsection 3. It is maximum is up to 7 years. So if it is up to 7 years, when it is 60 days. So if the charge
Let me have,
over to the investigation and because in the trial also, definitely will cooperate in the matter of cheating, but these things will have to be decided in trial.
absolutely. Here's an next.
I have a next.
Here's an next.
Page 18.
Last endorsement of 21/7.
Yes, yes.
21/7. 7 itself. What is your Yes, subsequent development. This way, that is not. These days, in terms of 21, 31, 7, 21, 7, 21, 7.
My lord, there is nothing to investigate. Because, my lord, it is for, my lord,
First. The Gosabi Learned Council, the petitioner for the accused, has really drawn my attention to the order dated 20 December 25, passed by this court, rejecting the bail petition, earlier bail petition of the accused upon perusal of case that. Upon perusing the said order, I find that the same, the bail was rejected on the basis of continuing investigation and adverse materials revealed by the investigation in that stage, which is for a learned additional people. Submits that case diary has been received. And please, it is placed before the court. I find that there's no, it is submitted that last endorsement of investigation was of 21/7/2025. Thus, I find that there has been no further investigation to the date of rejection on 2020. This learned counsel for the accused has submitted that the wife of the petitioner is unwell, suffering from some mental illness. It's drawn my attention to annex documents. It is also submitted that the applicable statutory period, considering the penal provisions given at this stage, is 60 days. That's fine, 60 days, 60 days. And that the petitioner has been in pre-trial detention for about 58 days till now. Undoubtedly, the investigation has revealed incriminating materials against the present accused seeking bail, and which has already been noticed in the earlier order rejecting the bail. However, since I have not seen further investigation up to the last day, keeping in mind the length of detention, the projected illness of the wife of the accused, dash. I would have considered that despite the adverse materials, the accused can be allowed to go on bail at this stage. Accordingly, is allowed to go on bail with one surety of the like and the satisfaction of the concerned learned court, subject to the condition number 1, it shall not respond. Number 2, it shall cooperate with the remaining investigation and be available for trial if one commences. Number 3, it shall not try to influence any witnesses. It shall not hamper or tamper with evidence. Violation of the bail conditions might entail cancellation of the bail. The return back is the bail condition stands disposed of. Allowed and disposed. Obligatory. Right to name of like this. Can we give you a daughter's name?
no, I am not senior. I am not designated.
No, no, your daughter's name.
She is Darshana Goswami, D. Goswami, oblige me. Oblige me. Let's keep my senior another court martial. So, madam, if they are
After lunch, after lunch. So, should I take up?
Yes, please. My lord, in fact, my lord, on the last occasion I made submission, your lordship has also recorded. The allegation pertains to the year 2018. The allegation is regarding some IAY scheme. And the allegation against the present petitioner is that he was then the bank manager of that concerned branch. So he has not correctly verified the self checks because some money were taken out by bearer check, self check. So the allegation, if your lordship, my lord, it is a longish FIR. I take your lordship to page number.
I think so, I might remember it also.
Yes. Page number 16. That is the forwarding report. And the allegation against me, your lordship will find at page 17, para number 3. It is more of a dereliction of duty. At best, it can be. But to attribute criminal offense on such stale allegation, 7 years back, this incident happened. It is a stale case, my lord. To arrest a 69-year-old man, some message should go to the police, my lord. They cannot use the law to the detriment of common people, my lord. 7 years back, somebody made an allegation. They were in their slumber. Suddenly, after 7 years, a 69-year-old man, you pick up from his house, you put him in custody.
Anybody, initially there should be time. Export is saying, no, arrest the drop of the hat. No, no, you don't know the allegations are also serious.
Allegation, see at page.
Arrest discretion is always arrest discretion. Some of the specialized agencies like CBI and all, I've seen myself personally, I've seen that
They
take
don't
some-
arrest as a
they
routine
don't,
court.
they don't take time. They take some time. They investigate.
They don't
Then,
arrest as a routine.
sometimes, you know, it is more considered decision. That should be the
And my lord,
notice for police also. It has improved, no doubt. It has improved because the whole process of arresting has been made. That is also one of the reasons why it has been made. All this compliance, all this. And anyway, so since I think CD has come. CD has come.
What offense he has committed, whatever he has done.
No, no automatic blanket, no automatic blanket. But sometimes due to elapse of time.
First, regarding the offense, what he has committed, this is the Xerox copy of this state. Those sets are received by being verified by the present and all being verified by the present user, those amounts were released. And now
Xerox copy of checks,
Xerox copies of
not original check.
not original checks. Now during investigation, police has in fact entire checkbook along with the original check slip, which were they are in intact in the checkbook. Police has seized all those checks recovered. This is the allegation of the during and those amounts which were public funds. Those after verification of those checks, those are so released.
Police also took a lot of time to investigate because time means loss of evidence. Time means loss of evidence.
Because time
No blanket cover, but when this thing, that's what I was trying to say, that when there is elapse of time, you know, when there's elapse of time, then greater scrutiny, greater caution. For arresting. So you can submit and I'll also see.
My lord, two more facts I need to.
Just a minute.
But two more facts I need to.
Just a minute. You have flagged the portions. You flagged the portions. You were arrested on which date?
He was arrested on 28/8/2025.
28/8.
was the brand transfer effect of the
Main allegation against him, that he has verified those ships. So after his verification, those are not so good. There are allegations against block development and many other persons here. Against the present accused person, he has verified those ships. And past photocopy checks. Yes. And the data during my investigation, those things along with. Is this custody necessary for investigation? No, that cannot be. That's the IO.
Their forwarding report does not say so.
IO have to say this first.
There are two more facts I need to.
Okay, now you.
My lord will kindly come to their forwarding report at page number 16. My lord, not even a single day police remand is sought for. Not even half day police remand. Just arrested, go to judicial custody. Along with him at page number 18, there were 1, 2, 3, 4. There were 4 persons who were arrested, out of which 2 or 3 have been granted bail by the Sessions Court.
Orders are there.
My lord, that is precisely, my lord.
Anyway,
But it is my instruction that you probably will be there in the record.
at
So-
least 1 or 2 has got bail according to.
Absolutely. That much I can say, my lord. 1 or 2 have got bail, my lord. I could have indicated the names of those, my lord. And my lord, he has retired way back on 31/3/2018. Therefore, there is no chance of even tampering with the evidence because now he is not there in the office. He is not there in the office, so he cannot tamper with the evidence. All the documents have been seized by the police. Out and out a case based on documentary evidence, that too after 7 long years.
Lot of scissors, seems.
Yes. Everything has been seized.
Voluminous case there. Let me have a look. See, I can keep it here. For some time. Amounts were disbursed to the scheme was scheme. And those successfully job takes place. Officer is also, the video is also one of the. Thank you. They were dispersed to genuine, not genuine, fake verification. The scales of the officer is verified by the present. And those original six were there in acting. Very reckless acting. Very, especially for a bank person. That might.
No, my lord, the video and the prime accused, because the allegation is against the video. I mean, substance of the allegation is against the video. And to my instruction, my lord, I'm extremely sorry. I'm not being able to tell them.
Don't be starting.
But they are on bail, my lord. I'm deeply obliged, my lord. That's my case, my lord. Because after 7 years, my lord, I don't think, my lord, and on the top of that, not even a single day police remand is sought for. Because they've seized everything. Everything is there, my lord. Now, at this stage, do they want to hold me guilty?
Significant progress investigation. Forensic report is also.
Yes.
Which has indicated that the check leaves are not genuine. Check leaves are not genuine. The present petitioner is directly involved. He conspired along with the video and all the other accused persons.
According to the IO, my lord, it is yet to be proved in the court of law. Let us not jump.
According to the IO, according to the investigation, according to the, on the basis of the investigation.
Whatever little I understand, my lord, investigation is done by the
Stage of bail.
We are on the stage of bail. Yes.
It's on the stage of bail. This stage. Even investigation is also not complete. So, it's very. Facts are dictated. No, they are on paper. At 2, right?
The item will be called, my lord.
No, I'll dictate it. I'll dictate and complete.
Okay.
for a reserve, more. Heard and this was.
My lord, two more. All accused are on bail.
Okay, I'll dictate it to only. Actually, don't take much time. I'll keep the CD. Submit.
Delivery order. Maybe number 185.
This bail application I could not allow. Both are dismissed.
That's true. All your lordship.
Highlight. Next matter.
Yes. My lord, this is nothing but a mercy petition, my lord, wherein my client has been arrested on 24/7/2025. And she is a lady, man. Having a son, my lord, who has been appearing in competitive exam, brilliant guy. 55 days behind the bar. Affair, my lord, may I take your lordship to page 12. Now, this is a long affair. I'm cutting it short, my lord, wherein paragraph, my lord, 2, allegation against me, my lord. She was a bank employee, my lord, in Canara Bank. Yes. She has transferred to different accounts, 1 lakh, then 1 lakh, then in D, my lord, under heading 1 lakh. Yes, 3 lakhs. Now, kindly see the FIR dated 1/1/2016. At the top of the affair, my lord, with page 12, 1/1/2016. Now, departmental proceeding with regard to banking service has been done. She has been removed from service in 2016.
He was a bank employee.
Yes, yes. And apart from that, my lord, she took a loan for a house. That house, my lord, she could not repay and it was auctioned and she suffered and now she's in rented placement. Now, all of a sudden, she has been arrested. Kindly come to the affair, forwarding at page 15. 25 July 2025, and she has been arrested on 24, 27, she has been produced. And she has been taken into police custody for 5 days, my lord, and thereafter sent to judicial custody. No more police custody, nothing, my lord, thereafter. So what I am on, my lord, if it takes for the investigating officer for a investigation of a case from 1/1/2016 till 2025, my lord, the date of arrest, my lord, and is it a case wherein, my lord, in every case, arrest is a must?
24/7, no? She's in custody.
Yes, 24/7 she was arrested, 25/7 she was produced, my lord. And here is a case wherein, my lord, one of the persons who has been named in the affair has been granted anticipatory bail by his honorable court. Absolutely on same footings. But I am not on that because parameters we got 438, 439 is different. But what I am on, that I started with addressing this honorable court, that is a mercy petition now. No other criminal case has been pending against her. I have been behind the bar for 55 days. After initial interrogations, my lord, nothing has been done. I have been languishing in jail. And my lord, considering this aspect of the matter, I with folded hands praying for bail of this lady, my lord. Any wrong been done, she will face the trial, my lord. And this is not trial, my lord. This is investigation part. That is my respectful submission. And there is a special provision in the CRPC for women, my lord. That is 437 proviso and new law is 480, my provision.
The serious come.
Yes, earlier you know, see, that's very well done.
Yes, Praveen Kumar was granted anticipatory bail, my lord.
Kumar, I am familiar with the name, but this is not my order.
Yes.
Yes,
That's
yes.
what he was the servant of the, head servant of the present, bank employee, and that's it, regarding the present, on earlier, regarding the materials available on record against the present accused person, his husband, one monthly wasn't also there. The present accused person is the bank officer of the Canada Bank.
Yes.
And his husband is also working with him. No, now only the petitioner is the present.
Right.
Yes.
I am recollecting.
Yes. Oh, what she has done, during his service of the Canada Bank, the very transfer. There are lots of allegations against him. What he has done, ATR, some of the allegations against him, against her is that, those KDR is complaint with the reinvestment scheme of the Canada Bank, those amount without authorizing the, without the customer, without being authorized by the customer, they have closed those accounts. And thereafter, by the entire amount of debt by transferred to a third party account. In some cases, they himself created a name Ma Babola Enterprise was so they want the partner, and to one other person, Bodun Kumar is also brother of the present accused by from the case director. And how all these amounts, the amounts paid by the from the case. But in the case diary, that is somewhere written. And regarding in some cases, when fixed deposit amount paid by the customers for fixed deposit, and those amounts will also transfer to some third party accounts by these accused persons.
Husband is in custody. Not paid.
Yes, 439, my lord, there is a difference between the two.
As part of their service,
This is DA. The investigation should have been. It's not.
2016.
That's unusually must have got stalled in between. Otherwise, this cannot happen. Should not never take names. Most complex of cases. Must have got stalled in between. Maybe. That you cannot answer.
Yes, basically 2016. How recently the petitioner
This last endorsement is last. Can you find question? The statutory period is 60 days for the
90 days.
409 is 409.
Bank of banker.
Yes.
Otherwise, others are 60.
Volume was paid when free costs up to 8/9/25.
Recent. Relevant question. This one part of
This is what for
possible. No doubt about materials against her.
sufficient.
If you have to grant bail, it has to be another consideration. Linked or whatever.
Not only one customer, the FIR itself reflects the
Husband was not arrested. Ranjit, he was not arrested. He was bail. Maybe CID came later into the picture. Otherwise, it's so long.
Initially, it's been registered as CID itself.
Initially,
Yes, it's 5/1/2016, the FIR has been registered. 1/1 is the FIR 2016, 5/1/2016 is the case registered by CID.
magnitude of, what is the magnitude of seizure of documents? Many documents have been seized.
From the FIR, it appears 3 lakhs. Ma'am.
Hard. Yeah, we assisted by. Also heard P. Whatever learned additional for the state. The accused hearing, namely Jumi Das, is seeking regular bail in connection with CID PS case number 1 of 2016 under section so and so. He is stated to have been arrested on 24/7/2025 and since then in pre-trial detention. Interestingly, the FIR is dated 1/1/2016. Lodged by one senior official of Canara Bank, Ulubari branch in Guwahati. With several allegations, the gist of which is fraudulent transactions done by the accused persons, causing losses to the customers of the banks, including those having fixed deposits. The present accused is one of the named accused in the FIR, along with 4 others. So if we are learned counsel for the accused submits that after her arrest, the accused, prison accused was custodially examined. Semicolon, that no other criminal case is pending against her. It submitted that she had also faced disciplinary inquiry. It is also fairly submitted that the accused, pursuant to disciplinary proceedings, has also lost her service in the bank. The case diary has been received and learned additional PP, Mr. Porter, to submits on the basis of the same that there are sufficient implicating materials against the present accused. And the investigation has found materials showing her complicity in the alleged offenses. It is also submitted that large volume of documents have already been seized in connection with the case. On a query from the court, it is submitted that section, the statutory period with regard to section 109 IPC is 90 days, while with regard to the other penal provisions, the same is 60 days. Full stop. Any other component to be seen by me? Want to see any other component of the case diary? Yeah. Yes. I have already checked on those portions. I've gone through them, like that's no doubt. No doubt. The case, as already stated, the case was registered in 2016 itself. And though there seems to be sufficient, seems to be significant progress in investigation, the same is not yet completed. Nevertheless, despite the progress in, despite the incriminating evidence revealed against the accused. Considering the progress of investigation, semicolon, registration of the case in 2016 itself, stop, comma, for a custodial examination during investigation, and no further prayer for such custodial examination. Yes. I'm inclined to allow bail to the accused at this stage. In such learned additional PP opposes the grant of bail at this stage, submitting that investigation is still there. Next. Accordingly, the accused. It is also pointed out that another co-accused was who had preferred a pre-arrest bail application was allowed such anticipatory bail. Accordingly, the accused is hereby allowed to go on bail. Give me a little more, 50,000. 50,000 with one security of the item. The satisfaction of the sexual learning. Following conditions are imposed. She shall not hamper or tamper with evidence. She shall cooperate with remaining investigation. Number 3, she shall not try to influence any witnesses. She shall not hamper. She shall not specifically not hamper or tamper with any documentary evidence. In case of violation of bail conditions, the prosecution will be at liberty to move an appropriate application for cancellation of the bail. Return back the case.
One more condition may be imposed because she is in a rented place. She may change the rent. She'll inform the court if change in a.
It is as the use is stated to be in a rented accommodation. In the event of her change in residence.
Deeply outlined, deeply outlined.
That I have not mentioned also. I forgot to mention. I forgot to mention, but if we are not sure, better not to mention.
Deeply outlined.
Actually, we should not be wrong.
Right.
Okay.
I think 30.
Well, it is a regular bail application also. FIR is at page 9 also.
CDS come.
Yes, it is. Let's say only on the suspect I was arrested, let's say on 3rd of August, let's say. And in this case, let's say already, let's say dozens of accused have already been arrested by the police. Let's say. And the Honorable Additional Michigan Session Judge, let's say, has granted bail to the co-accused, let's say, even to the name accused. Anticipatory bail has been granted. Already 44 days, let's say. Merely on suspect. And so far, forwarding report defense that, let's say, I was 5 days in police custody, let's say.
Personally, is a
Lordship,
contractor,
he is the name accused, Lordship. And
contractor of the house.
Lordship,
That is the name, because some people at point of time, some construction of it, the residence of the victim. And police have also some of the laborers who were working in construction was also involved, police initially arrested one Akbarali, one Sadekali. There are many other accused persons, and some of these were to study the name of the prevention after investigation, and the also for the pending and against the present accused person. Personally, materials were found. The contractor. No, personally, my opinion, there is no, he is allowed to, personally loan, he is allowed to loan bill at one point of time because he was the contractor. The other laborers who were working. They were suspects. Some were involved. Later, Abdul Razak, these 6 months ago, he described in detail how he, along with others involved in committing the property and there are other cases also, we also have additional one cases also. Whoever the decorates, whoever, judges also not spared. But they are judge, that's CBI judge, owner of them. Anyway, it's written here. So at that point of time, while committing that offense, other Sikram and everything, what was there in the residence of the victim and those materials were used because they on that day they in fact without keeping those materials inside the house, they kept those outside the house. That is why they were suspected. Yes. So this is the elaborate statement. Yes, there are some other statements the applicants are later. All statements, of course, self-incriminating. What is the other metrics? Metrics is other core statements also. Investigation is still going. Caesar is also there. There's some of the those articles we see taken away at the time of the he was arrested on Lordship 3825 Lordship. Yeah, he had 38. He had 5 plus police custody Lordship. And Lordship. You were saying something. Lordship, I have stated, Lordship, paragraph number 7, Lordship. Why I am not involved, Lordship, that the accused petitioner stated that the incident was happened on 27-28 of the month of July at Guwahati, but the accused has been residing in his house situated in Dhubri since June 2025. On 29th of June 2025, he performed his nikah with one so-and-so, a resident of his own locality. And since then, he had not left the native village, which is well known to the villagers. And as such, only on suspect, he has been arrested, Lordship. It is his stand, Lordship. Regarding him. Leaving aside his own statement. What admissible. Technical analysis. CDS, mobile location. Present accused Abdul Razak alias Abdul Rajak is seeking regular bail in connection with Janmari PS case number 195/25 under section 311 of BNS 2023. He was stated to have been arrested on 3/8/24 and presently in such allegations in the Azahar dated 28/7/2025 by one Sri PC Pratap Sundar Das is regarding omission of dacoity in their house on the intervening night of 27th and 28th of July by some persons with with face masks. And in the said dacoity, many of their valuables were stolen and they were threatened with the weapons. The present accused was arrested during investigation. So the learned counsel submits that the accused was also custodially examined for 5 days after his arrest. And it is also contended that on the day of the incident, it's also contended that he is innocent, and on the day of the incident, he was in Hubli district pursuant to his marriage. On the other hand, Hubli Kotapur learned additional PT along with the case diary submits that sufficient incriminating materials have been found and that the investigation has found the involvement of the present accused along with other co-accused in the alleged dacoity. It is submitted that from technical analysis, the location, the presence of the present accused is indicated at the place of occurrence, place of occurrence. The IO has strongly objected to grant of bail. The case diary is produced before me, and I have perused some relevant portions. The contentions of the IO are supported by the learned additional P. It is stated that investigation has revealed the involvement of larger gang acts of dacoity. In previous cases, where such alleged offences are also registered against these accused persons. In view of the said circumstances contended by the prosecution, it may not be prudent to grant bail to this grant bail at this stage when investigation is still appears to be also still in active progress. The bail petition stands rejected and is still returned back at least. Investigate forward.
Hey, please. Lordship, regular bail petition, Lordship. Petitioners are behind the bar for last 40 days. They were arrested on 9/8/2025. One of the Lordship BNS corresponding to 302 IPC Lordship. Lordship, you can see there are 4 petitioners. Petitioner number 2 is the wife. Petitioner number 2 is the wife of petitioner number 1. And 3 is the Lordship son of petitioner number 1 and 2. And 4 is the daughter-in-law. All the family members are behind the bar. What happened? Lordship, may I see the FIR, page number 12. lodged by one police officer on the basis of a GDN. May I read, Lordship? I beg to state that on 26/7/2020 at about 9:10 a.m., one Sri Bitipon Hazarika, he is the complainant, son of so and so, resident of so and so, submitted a written petition at this police station. In his petition, he stated that on 25/7/2025, at around 8 a.m., he received a phone call informing him that his aunt, namely late Jyoti Dodia, she is the deceased lordship. And she is the lordship elder sister of the petitioner number 1. Daughter of so and so, district Tinsukia Assam, had allegedly committed suicide by hanging at her own residence on the same day. It was further alleged that neither the family members of the deceased nor the head pradhan of the village informed the matter to the police, and that the family members had buried the dead body at the backside of her residence at Sorudira. In this connection, Kakota PS GD number so and so dated 26/7/2025 was made, and the requisition was sent to Deputy Commissioner seeking permission to exhume the dead body from the graveyard. So dead body was exhumed from the graveyard. Permission was granted, and a UD case was registered by Kakota PS UD case number so and so, which was endorsed to me for investigation. During investigation, the place of occurrence was visited, witnesses were examined, and the crime scene officer also visited the spot in presence of Srimurti Bharati Bora, Executive Magistrate, Munduma Revenue Circle, and witnesses. The dead body was exhumed from the graveyard situated at the backside of the residence of Sri Robin Dogotia. Petition number 1, Lordship. The son of so and so, resident of so and so, who is the brother of the deceased. The deceased was identified by him as late Jyoti Dogotia. An inquest was conducted by Srimurti Bharati Bora, Executive Magistrate, Munduma Revenue Circle, in the presence of witnesses, and the body was forwarded to Macomb Medical College and Hospital for postmortem examination. Today, the postmortem examination report of the deceased collected reveals the following. Number 1, opinion as to the cause of death is kept pending till receipt of viscera. And blood analysis report from DFS Kahilipara, Guwahati. Number 2, injuries present over the body were antemortem and caused by blunt force impact. Number 3, approximate time since death, 2-3 days. The viscera of the deceased, late Jyoti Dodia, has been sent to FSL Guwahati for analysis. From the above facts and circumstances, there is sufficient ground for suspect commission of an offense punishable under section 1031 of the BNS. So, Lordship, this is the facts of the
aunt of the informant.
aunt of the Lordship, aunt of the informant.
And how she related to this?
Yes,
You had
petitioner
said-
number.
You had said, but I forgot. Can you repeat?
She is the Lordship elder sister of the petitioner number 1.
Elder sister.
Yes, elder sister. She is unmarried lady, Lordship. And she was residing near the house of this petitioner's Lordship, the neighbor. So what happened, Lordship, on that fateful day is that, Lordship, the son of the Lordship petitioner number 3, as a grandson of the petitioner, number 1, had gone to the house of the deceased and found her to be in a hanging condition. And after that, he shouted, and all the petitioners arrived at the place, Lordship. And the only mistake that they have committed is that they did not inform the police nor the Lordship other responsible buried the Lordship body. And their Lordship connected with the Lordship deceased Lordship. Initially, it is a case of Lordship suicide. The suspicion is their Lordship. 40 days behind our Lordship.
Antemortem, some injuries also.
Yes.
Anyway, so.
Out of Lordship that could not think properly and buried the body, Lordship. 40 days, Lordship, they were thoroughly interrogated, Lordship. No previous Lordship antecedent.
So anyway, diary has come.
But
What has you? Can you guide me? What is the
here, why not?
outcome of investigations?
Outcome.
What does it say?
Why not? There, why not? There, why not already stated. They are all are legally. These two why not very legally staying nearby. Nearby. And one of the fact is that immediately they have stated there is a case of suicide by hanging. And after they, what was there, like they have to inform the police and the order for them. That was not made. Immediately they buried the dead behind the backyard of the house. Now the form whose backyard that the body was
Exhumed.
yes, that was the petitioner number 1 and the second is the wife of the petitioner number 1, and 3 and 4 are the father-in-law of the petitioner number 1 and 2. Here, In this case, my LLC might have filed categories that might have failed objection. Because my lord, here, my lord, the candidate.
I'll have a.
City. And my lord, during the course of investigation, my lord, these might have examined many weaknesses. When in some cases, one these statements are also available, my lord. Well, clearly indicated. And my lord, in the PM report, my lord, there is no, my lord, that I have described these, my lord, said, my lord, the case report, my lord, said. But from the PM report, my lord, some injuries are found, my lord. And those injuries are anti-mortem in nature. Those injuries are anti-mortem in nature, my lord. And my lord, they are from the same place, my lord. The many of the, my lord, witnesses, those were examined. They are from, my lord, their relative and also from the same villages. So at this stage, my lord, there are much probability of comparing those witnesses. Made, my lord. That information also, like,
Unnatural definition.
shares.
What do they say? Their statements also recorded. Right?
Some, one weaknesses, some I have type mark as a star, my lord, in weaknesses. Their implications is very much clear. But before the incident, my lord, some dispute was there.
I mean, so far it has emerged as a case of suicide or homicide?
At this
Not
stage,
clear.
my lord, because, my lord, that is their statement is the suicide, my lord. But on how, my lord, immediately they have done everything, my lord, without calling the, my lord, these people. And my lord, the suicide, my lord. Some, my lord, villagers are there who stated that, but my lord, how it is, my lord, committed, my lord, nobody knows about the fact. Many things are there, some things are also there.
At this stage, lordship, it may be a case of suspicion only, boss.
I don't, they didn't conceal the things and inform. Then obviously, my lord, this submission will not come. Only after that, man, considering all the facts, man. There are the only things.
Injury is present. That is one problem. Injury is present over the body.
And
Antemortem and both by blood. That's why opinion regarding death.
Yes, sir.
Viscera also is suspect.
Yes.
Ultimately, consider 40 days, they have been thoroughly interrogated, lordship. Any condition, they will cooperate, lordship. They are all the family members, lordship.
We are connected. 40 days by the otherwise also by the.
The witness stated that she was very weak and walked.
Yes, madam,
But
that's
the state
still
is
there.
not capable of hanging or something.
Yes, ma'am. That part is there.
It's not a conclusive, thing, but still. Let me just. They were custodially examined for a few days.
Lordship. Petition number 3 for 2 days.
2 days.
Police custody.
There are grave doubts. It was still in the state of investigation.
Only
It will require further investigation. There are some threats. There are some grave suspicions. There's some aspects of the matter.
Actually, they will cooperate. They are the local person also. Local people of that. Yeah.
More specific, allegations of against all of them. Right? Against all of them. Or can we consider one of the daughter-in-law to be? First pilot, the witness pilot. I have not been able to segregate. It's involved. Second part, guess maybe. Part A is involved. Prima facie may not be yes or no. Because it is not council matter. Then thereafter somebody made an affair. But now the case will. Collective criminal liabilities. Sometimes you never know. Yes, if it is not possible to segregate. Someone might be roped in also. I also could not segregate whatever I found.
What you can consider period of detention.
But some papers, 483 bail application by 4 accused persons, namely so and so, seeking regular bail in connection with Apu Kothar, yes, case number 43 of 25 under section 7. The accused persons were stated to have been arrested and in pre-trial detention since 9/8/2025. The allegations in the FIR dated 6/8/2025 is that the elder sister of accused number 1, who was a single woman, was found dead and died, and she was buried by these persons living in the adjacent house. And subsequently, upon filing of the FIR, subsequently the dead body was exhumed pursuant to GD number 3 dated 26/7/25. And sent for PM examination. It is also stated in the FIR that injuries were found on the body. The Learned Counsel submits that these persons are all members of the family and all of them are in custody. And after their arrest, they were also custodially examined for 2 days. He also learned additional people. Submits the case diary report of court and contains that investigation is continuing into the facts and circumstances surrounding the death of the alleged victim. Final opinion in the PM report is not given, but antemortem injuries as mentioned. The IO has submitted a bail objection. Statements of 2 witnesses were also recorded before learned chambers. in which the witnesses have stated about the suspicious circumstances surrounding the death of the victim pointed towards the conduct of the accused persons. Though all the accused persons, out of the accused persons, the accused number 3 is stated to be the son of accused number 2, 1 and 2, and accused number 4, the daughter-in-law. It is contended by the IO that bail at this stage could prejudice investigation as there are many witnesses of the same village. The given facts and circumstances, while I deem it proper to reject the bail prayer of the petition, accused petitioner number 1, 2, and 3. But as all the members of the family are in custody, therefore, I deem it fit to grant bail to the daughter-in-law of the family whose petition number 4. So, according to the accused number 4, namely Bhagyasri, is allowed to go on bail of rupees 30,000 once year, subject to the condition that she shall not hamper or temper agreements. However, for the moment, the bail prayer of accused petitioner number 1, 2, and 3 stands rejected at this stage.
But can be considered two lots, wife of the.
I thought about that, but for the moment, you can file another one later. Let the investigation proceed. Sometimes it is very difficult to decide actually. You know, maybe she is more involved, we don't know,
Lots.
but it's guesswork.
Lots.
Actually, just trying to balance something.
Lots.
At least one member.
Lots.
Yeah.
Deeply of it.
May, is your lordship. Lordship, this is a regular bail application, lordship, 86 days in bail custody, lordship. Last day, lordship has called for the bail payment from 63. Lordship, co-accused lordship in this case, lordship, mastermind of this case, lordship, he was granted on bail on technical ground, lordship.
Notice issue. Notice. BMS.
Yes. Notice, lordship, regarding.
No. The technical grounds means.
Take the notice, yes, lordship. Now, lordship, we have lordship already 3 days. Police remand, he was thoroughly integrated in police remand, lordship. So, lordship, considering the length of detention, lordship, 86 days in jail, lordship, and the co-ec is already released, lordship. I'm not make.
Charge sheet.
And then, lordship, after charge.
CD has also come. No, only this communication.
Even after charge sheet, lordship, and can grant bail, lordship, in the
What is-
Purva case.
Yes, that.
That.
You can take a. There's no bar in giving.
Yes, no bar.
Fake currency.
Fake currency,
Fake
lordship.
currency.
Yes.
Serious offenses. It was again. Accused hearing. Namely, Saiful Islam seeking regular bail under 483 BNSS. Connection with dispute PS case number 533 of 25 under 179 BNS. The case arose out of FIR dated 22/6/25. The alleged offenses pertain to peddling of fake ICM, fake Indian currency notes. Fake Indian currency notes. The learned additional paper submits the report dated 16/9/25. We received from the IO stating that upon completion of investigation, charge sheet has been submitted on 16/9/2025. It is submitted by the learned counsel. Another co-accused against whom there are graver allegations has been granted bail by this court. Nevertheless, the of the completion of investigation, also length of detention, pre-trial detention since 24/6, within bracket, 24/6/25. The accused is allowed to go on bail 30,000 satisfaction. Due to the condition not strong, not indulge in any activities, including any activities of peddling of fake currencies, etc. Shall not hamper or temper witnesses. Shall not try to influence witnesses. Violation of this.
Chief Judicial Magistrate come with
Yeah, opposing. Yes. Sure, the learned additional PP opposing the prayer for bail submits for requisitioning the scanned copy of the case report. This will be part of the report.
Yes, sir. We have
Petition.
recorded.
Yes, I'm recording. Communication will keep part of the record.
Mid-page. The petitioner is inside the jail worship till 25/7/2025 and FIR is at phase 9 annexure 1. Phase 10 is the relevant portion. The respectful statement of the complainant before the summary is that on last 15/5/2025 at night about 8:30 p.m. while the other accused persons remained at the courtyard of my residence, the accused number 1 trespassed into my room and searched my brother-in-law, Sri Rakesh Nath, and finding him not in the room, they returned back by making an accusation that my brother-in-law, Rakesh Nath, had molested the daughter of one of the accused persons. Thereafter, they found my brother-in-law at our courtyard and the accused numbers 1 and 2 forcibly dragged my brother-in-law into the residence of the accused persons, and they severally assaulted him, causing grievous injuries. In order to kill him, they also kept pressing his leg. On hearing the hue and cry of my brother-in-law, the villagers gathered, and with their help, my brother-in-law was rescued and he was treated at Lahorigat Modern Hospital with serious injuries. However, for better treatment, he was referred to the Morigaon Civil Hospital, where he is now undergoing treatment. During investigation, detailed information will come out. False statement has been posted through mobile against my brother-in-law. It may be mentioned that the Morigaon Civil Hospital has referred the injured to Guwahati. It is therefore prayed that a case may be registered against the accused persons under the aforesaid sections of law and by summoning the accused persons and recording the statements of the witnesses. Necessary action may be taken against the accused persons. So accused number 1 is Horen Nath. He was taken into custody. Lordship. My submission is that, Lordship, this is the counterblast of my FIR. That is annexure 3, page 20.
Diary has been received. Injury report is there. Yes, I'll just.
Page 20,
Just a minute.
annexure 3, Lord.
Here, the petitioner is Horen Nath,
Yes, Lordship.
was
In-
arrested
in
on
BA.
25/7.
25/7. 25/7. In BA, Lordship.
Where should I go? Page number?
Page 20, Lordship.
Okay.
This is the
Grounds
actual-
of arrest.
Yes. Page 20, annexure 3, Lordship. Copy of FIR.
Okay. Your attempt.
Yes, this is our FIR. On 15/5, we have filed. Lordship. The informant begs to state that my husband Dipen Nath stays at Guwahati for his works. The aforesaid accused is a youth of notorious character. Today, 15/5/2000, 25 in the evening at 6:30 p.m. while my minor daughter, so and so a student of metric, was studying at her room. The above mentioned accused having trespassed her room and molested her and tried to do bad things. However, due to her hue and cry, the neighbors came to the place of occurrence and saved her modesty. On last 14/5/25 at about 2:30 p.m. of the day, the accused, taking the advantage of my absence as I have gone to benefit, also entered the room and molested her, and today also he repeated the same. It is therefore prayed that Your Honor may be pleased to investigate the matter and take necessary action. So, Lordship, first of all, our FIR was not registered, then we lost complaint, thereafter it was lost, Lordship, registered. Page 21, received and registered by Laurigar PS case number so and so under section 329, 375, 1, read with section 10 of the POCSO Act. And accordingly, the accused was arrested. The name of accused is page 3, Lordship. Mr. Accused Rakesh Nath.
You are seeking bail in connection with Lahorigat 136. right?
Yes, Lordship.
Right, which was
Yes.
against your friend. This was registered after complaint as Lahorigat
Lahorigat, Lordship. that is
163.
163. 163 is filed by us under POCSO Act. But we have filed in 15/5. Lordship will find page 20 and
Complaint.
to the officer in charge, Lahorigat. The FIR date is 15/5, Lordship, the date of incident. Then thereafter, it was not registered, so we filed a complaint. Then the Lahorigat PS was registered, Lordship, under POCSO Act. And in the meantime, they have filed another counterblast FIR, Lordship. And in respect to this FIR, Lordship, already Rakesh Nath was arrested. Forwarding report also I have enclosed as annexure 4, page 26. POCSO case accused was arrested and he was forwarded to jail, Lordship. Forwarding I have annexed, Lordship, page 26, 27. He was arrested on 23/7/2025. As a counterblast, Lordship, this FIR was filed on this ground, Lordship, in AB of the persons were granted interim bail, Lordship, at the time. Police case there, Lordship. My humble prayer before your Lordship, and this person is a physical disabled person. That document also I have enclosed, page 28, annexure 5. After an accident, he becomes 60% physically disabled person. Page 29.
He was arrested on 25/7.
Yes, Lordship, 25/7. Maybe all the persons are interim granted, they appear before that.
Yes, ma'am. The forwarding report says that the allegation pertaining to that POCSO case is false, according to the forwarding. So any materials there?
That people wanted.
It was fabricated to justify this. It's written in the forwarding. They say this is a count.
It's instant to place on. By 50 by getting right. Their reference. 7/5/7/35.
No, both are on 15/5.
No, my affair is also dated 15/5. Lordship can see the original.
Complaint was on 15/5. Both are on same day, but they are, it was not registered.
Then present paper is on 25.
25. Yes. 20.
That page 11, 23/5.
23.
Page 11, their affair is 23/5.
And yours is 15.
15/5.
But registered later.
Date of incident is 15/5. So incident occurred on 15.
Can I have a look?
Yes.
Briefly. Council for the used. When seeking regular way, 483, Oregon case 136 of the. He's in pre-trial detention on arrest since 25/7/2025. Third council submits that the present is lost against the present accused and others was a counterplus to a complaint lodged from their side regarding the alleged molestation of a female member of their family by the alleged victim of this case. The allegation in the present case is that the victim is assaulted by the accused persons named in the fire dated 15/5/2025. 23/5/2025, right? 23/5/2025. Lost by one, Deepali. His diary has been received. Placed before the court. Medical report indicates simple injury by blunt object. However, abrasions were found in the neck of the injured person named Rakesh. The forwarding report, the time of arrest of the present accused, allegations about sexual assault made by inside of the accused persons been stated to be false and fabricated. Seen the progress of investigation. The Honored Council submits that the present accused is a physically challenged person, drawing attention to disability certificate annexed as annex of right. The same is stated that the accused suffers from 60% disability person to a road traffic accident. Investigation is not yet complete. However, in the given circumstances and some of the facts this above, the accused is thereby allowed to go on bail of rupees 25,000. One severity of the life, the inspection of the concern, learned court, CJM Morigaon. Sessions. Concerned learned court, subject to the condition. We shall not hamper or temporary. We shall not intimidate or harass the informant or try to or try to, and we shall not try to influence any witness. Violation. Return the case that when petition stands, allow them disclosure.
Item AB 2178.
So
The
this connected,
other accused persons.
Item 28.
no, this used. No, the petitioners hearing, how many petitioners were there?
Onto the five petitioners were there, five accused persons are there in
Yeah,
the
yeah, the four, these petitioners herein were granted interim arrest bail on 5/9/2025. Pursuant to which they stated, pursuant to which they appeared before the IO, as stated by the prosecution. And revealed in the case there, which is produced before the court. Their statements are there. It may be mentioned herein that perusal of case there considering various factors including length of detention, the arrested accused who is mentioned listed as accused number 1 in the FIR was granted regular bail by this court. Connected bail application. The given facts and circumstances, the interim bail granted to the present petitioners is hereby made absolute, subject to the conditions. And the conditions. Disposed, allowed and disposed.
Deeply applies.
Not received case diary. We should go fast.
It's the fourth time I think it was.
Oh, I see. Anyway, we will extend it and list it after vacation. Is it okay? What can you do?
Last week, day after tomorrow is 19/9, another case is arising out of 7 or 5. Can it be on 19 day first?
In that case, maybe. Is there not yet received? They submitted that connected bail application is fixed on 19th of this month. Issue fresh requisition for case diary.
AB number will tell you.
I will just,
AB number.
just the interim order passed on 29/5/2025 shall continue till the next date of listing. A list on 19/9/25 along with, now you tell me.
Along with the lordship, AB number 2201/2025.
Today, the court occasion, the CD is not there. On the last occasion, the specific order was being passed, so it will be punished today. So I pray your lordship for making the interim measure. Actually, that the other accused person are also being granted bail. Your lordship have the order that the entire family members were being taken into custody. Accused number 1, 2, and 4 were behind the bar. The father, mother, and the brother.
No, actually, any about what are the facts and circumstances of the case. So we have to go deep. Otherwise, after vacation, why is it not coming? It should come. So several dates so that a specific direction also last week. Last date. You're right. Pointed out this. There, furnishing a report will need some more speculation. Anyway, case diary is not yet received. Here was the last order dated this out. Issue fresh reputation after vacation. List after vacation on 17/10/2025. Interim bail granted on 22/5. 22/5. Continue with the next list. Also fast. Up to date case diary was called for.
After the basic artist.
Oh, they're not taken back.
All other quick lists are released on bail, so absolute bail. There is a delay of 20 seconds plus the FIR. After complete the preliminary process,
Anyways,
FIR is page number
no, it's
9 euros. Other quick lists are released in all other, except this petition. But there are some team protection they can be given. The case is pending for long days. 7-8 dates already taken university since 17 June university.
he's the
Husband.
husband. The informant noticed one rope below the bed of this person.
His younger brother was present at the spot. There is no any other note evidence. So only suspect. And after 22 days, he was the funeral process, everything is complete.
Which person? We have not specific which person.
The protection that can be.
Anyways. The problem is that they have obviously didn't retried this prayer because of the delay after some point. They have not gone back. This has not gone back at all. It creates a dilemma for the court also. Anyway, what do you suggest? Because of the allegations, I have some vegetation. I have not gone deep into the backgrounds. Superficial. Yes. What is the CD it is up to?
We have to choose 25.
Little back. What is the material?
Every put is pending.
PM report is important.
Incident took place on 24 September, Apollos and 8 October 22. Protection mechanism. Totally 9 dates already gone.
The allegation is that his sister was killed. Right? You have a look. I will take it off after something. After something.
That's it.
Or tomorrow. Are there?
PM report prepared, but
PM report is every
uncompleted.
opinion is not given. But any
Pending.
what kind of hanging? Antemortem
Of big push. That is not big.
not reflected. But forensically, it may be possible to say whatever. Because the direction of the ligature is different in angle, suicidal and antemortem. It will be like this. Same.
Regarding cause of death has been kept pending. This is the suggestion.
Can you get it before vacation? Possible. We'll try. Case diary is not yet received. The
Case diary.
case diary has not been received. The learned counsel reiterates his fear for injury possession order submitting that some of the co-accused have been granted interim bail. Nevertheless, considering the nature of the allegations, for the moment, let the updated states is there be tried to be procured on 25th. We'll take a chance. Can I keep this for the question? Like, least on 25 minutes.
Where is it? Anticipatory last one. Just a minute. Yes, please. Anticipatory application one, FIR page 16.
Diary has been received.
I'm not named in the FIR, mother. May read the FIR. The informant gave his 3 vehicles to one Noyon Deka and Gogan Busu
For hire.
For leasing them out, madam.
Yes.
They have a shop called madam rent car something. Once we turn the page, madam,
And then what happened?
madam, page 24 is their forwarding report. Madam. You find down the correct point number 2, madam.
He's not, who is he? It's Noyon Deka.
Yes, my lord. Chibu Singhal admitted to handing over all the vehicles to one Sadikur Rahman Chaudhary, madam. Can you turn the page, madam? Madam, I took one vehicle that is in the FIR, page 28, my lord. From that said Sadikur Rahman Chaudhary, my lord, on as a mortgage vehicle, my lord. Page 29 is the operative part, my lord. Whereas the first party is that Sadikur Rahman Chaudhary is mentioned in the forwarding report, my lord. He needed money for his personal necessity, asked for loan of rupees 1,80,000 only. Also mortgage his vehicle, that is Jeep Compass, having registration number 99988, madam. That is one of the vehicles mentioned in the FIR, madam. That is my complicity, madam. I took one vehicle, not even on rent, madam. It's a mortgage vehicle.
In Noyon Deka, the Gogan Busu are the proprietors of the one. You rent my vehicle. Here. The vehicles. But they very documents. And one person there.
They hire, take vehicles
They take vehicles.
and give it on hire.
Give it on hire.
2 people.
On 2 people. One person gets, you know. I'm not sure. You put all the vehicles. Which name is?
His name is Sadikur Rahman
Sadikur
Chaudhary.
Rahman Chaudhary. Yeah. Sadikur Rahman, the vehicles. And they don't from these people of the Sadikur Rahman Chaudhary. And the guy, so this petitioner took the vehicle from Sadikur Rahman Chaudhary. For bring some money. He kept the vehicle in position that because money regarding the money that I is kept in vehicle. Vice versa. Therefore, I just figure out that Sadikur Rahman Chaudhary, the water black fish from up to applicable. The chief declarer, Nemo score.
Removal score is the petition.
Yes. In the meantime, my lord, the FIR and accused people will granted jail, my lord. It starts at page 35, the operative part, page 37, my lord. Whereas it says that all the vehicles have been recovered and investigation sufficiently progressed. my lord.
Other persons are there, passing so low, Sadikur Rahman, they are also involved in this case. Because recovered from his position, when he get the other cases, one more than that.
For investigation stays,
Investigation. There are several vehicles, as per allegation, several vehicles, single. All the vehicles are yet to recover. Some vehicles to recover.
The vehicles have been recovered. It's 37 Nochibu Sima. Paragraph 6 of the FINM for these questions. Last one, the vehicles are already recovered. What you will see the sections at
From my own record, this is full sort of thing. We have handed over a vehicle to particular government studio. Now, passing to the other thing. We also take the vehicle to the particular government.
there's a good thing here that GPS tracker was deactivated on the way.
Yes, on the way, sir. When they took the vehicle from the government, they deactivated the GPS system.
you will see the sections. Only 409 is there. The new 409 will possibly not be applicable to me. Rest all available.
Can I have a look at this case guide?
Yes.
We go some. The petitioner name site on the plus parameter. Basically, pre-arrest bail in connection with Itanagar case number 42 of the Coincidence section.
Many people, all the vehicles,
So that part is confined to the FIN. I took one vehicle in lieu of my money. The security money.
In lieu of the loan, you kept the
I
vehicle.
kept the car, man. I never knew that the car is stolen or misappropriated or something.
What are the materials with regard to him specifically that it was recovered?
we let him do
Recovery of multiple vehicles,
No.
one vehicle.
from one vehicle.
One.
That vehicle given to me by that person.
Yes, on the vehicle and the vehicle, but
The learned counsel submits that. That's when the case diary has been received. It is submitted by the learned counsel for the petition that the one of the prime accused, Sadikur Rahman Chaudhary, had borrowed some money from him, and when he was unable to pay, they agreed to keep his vehicle for some time. And subsequently, your client kept the vehicle,
Yes, he kept the vehicle. But he thought it was Sotikura Raman Chaudhary's vehicle.
but it was, he was unaware that the said vehicle was part of group of vehicles which were taken on, which were taken on hire by the said Sadikur Rahman Chaudhary and others, and sought to be fraudulently sold to other people. The learned additional PP submits on the basis of the case diary that the said vehicle was indeed recovered from the said the present petition. On perusal of the case diary and the statements of some of the witness, I find that they tell us they tell a somewhat different story regarding the involvement of the present petition. The materials indicate, in prima facie indicate the association of the present petitioner as well in the activities of the said Sadiqul Ahmed Choudhury. There are materials to indicate that he, along with other accused, was very also involved in selling some of the vehicles. In the given facts and circumstances, the instant matter does not appear to be a fit case for grant of anticipatory bail, especially at this stage where investigation is not yet complete. Accordingly, the same stands rejected, returned by the case there. There are some materials.
There was one submission, Malak.
Appears to be the record actually.
Only one more submission, Malak. Beg my lost pardon, Malak.
Yeah, sure.
The 3165, Malak. The only section non-bailable in this case is 3165, Malak. That is earlier 409, Malak. I am not associated to the informant in any manner of being his agent or manager, anything, Malak. The other sections are completely bailable, Malak. Seeing that aspect of the matter, Malak. Even if it is assumed that I took his vehicle, Malak, would at best be Malak, earlier 411, Malak, which is only 2 years, Malak.
411 is non-bail.
But only 2 years, Malak.
Okay. Should not. The years matters.
Malak.
Probably it's okay. Active.
Black.
Okay. What is this allegation?
Allegation is lordship that was under section 108 that abatement to suicide. That the main accused is against Ankit Kumar. He is granted bail lordship after arrest. He was granted bail by the Somali court. And against him, there is no specific allegation what
Against the present petition.
Yes. In the FIR.
Who committed suicide?
That one person who gave some money to lordship that Ankit Kumar, he was supposed to sell his institute to that deceased lordship. He took some money from him and subsequently demanded more money and demanded that it should be paid immediately. Otherwise, he will think of some different action also. So thereafter, he committed suicide. That is the idea. And during that pressure period, that implication is that the present petitioner was also with that Ankit. And that suicide note, your lordship will find that I have enclosed at page 26.
Suicide.
Yes, it was circulated in social media. Thereafter, he had taken screenshot and that. Given.
Anyway, is there is come.
Yeah, that's one thing I'm pointing out to lordship that the interim order 4/8/2025 that part lordship may kindly see. Because that interim was granted after lordship that considering the materials in the case diary and allegation in the FIR. So that your lordship will find paragraph 5 of that order lordship 4/8/2025. So if any new material is there after that, that will be considered.
Pressurizing.
That we are
Yes, so my mouth is the amount of money. Later on the pressure built up. And the money.
And they committed suicide.
In the present petitioner, along with one person lawyer, they have calculated the allegation against the institute. That's why the institute became insolvent. And everything else like much against the.
In fact, regarding that, lordship, spreading rumor, that observation is there in paragraph 5 of the interim order, that no such screenshot or any documents were found by the investigating officer.
But from the statement of the petitioner, he appeared and recorded his statement of he has download of voice and that's request. If not any relation gives, but the third party sometimes get touch with that. What's it can go to the statements of the other
Late also.
execution and that suicide would also lost.
No, suicide note, yes, annexed, I've
Yes.
gone through it.
That is the effect of the better part.
It's not a great feeling going through any suicide note, but I had to go through it.
Well, I have given that to judgments of honorable apex court also that Lordship is well aware that in case of abatement of suicide, that there has to be direct connection with the death of the person. That instigation part or abatement has to be there.
Yeah, that is true. I mean, most of many cases of 306 actually, what is being alleged, the grievance which is being sought to be addressed by invoking 306 is a disconnect actually. There are certain circumstances that led to suicide of a person. Myself or someone may be responsible in some way for that circumstances. I may be part of circumstances, but that might not amount to abatement. Abatement is, you aided the person, instigated the person. Or there's another, that is not the definition. Same definition as 106. Conspiracy is different. Conspire to, and then aid, you help,
107.
somebody wants to commit suicide, you help him with the rope or something, just nothing funny about this. Then, an instigation and aid, instigate, aid, that kind of thing. Or another, from case law that has come. Another thing, that you create a situation where the person is left with no option but to commit suicide. Then also, that is an interpretation.
Exactly, those things are there in the two judgments.
There is an interpretation that create a situation where a person is left with no option but to commit suicide. That is an interpretation of law. But generally, we all agree that nothing in this world justifies suicide. Life is too precious. Nothing does that is, even in the most developed and well-developed countries also, people commit suicide. Why? Then why do they have all happiness in the world? Supposedly. But there also people commit suicide. Why? Because
it's a mental state of the person.
It's a suicide attempt. Suicide is nothing but a cry for help. So if the person gets that support at the crucial time, nobody. So there is nothing. These things are easier said than done. But the pain that it inflicts, the trauma that it inflicts on the family, spiritually also it's very bad. It's a different chapter.
Those amounts has to be paid, Lordship, to Ankit, not to the present petitioner.
Many people go back, I agree with you. But I'm convinced about it. Many of these situations where 306 is being invoked, there's a mismatch. Maybe we need a different offense, lighter punishment, that you're responsible for creating a situation which there's a linkage between your act and between your act and the act of suicide. But abatement is something more. Abatement is something different. Unless those presumptions of law come, that 113A, unless that kind of presumption comes, married woman, then it will be a little easier. Then you have to just connect the dots, cruelty, harassment, those 7 years of map, that kind. Then you get, except that other people, it's very difficult.
Those presumptions are
So
not.
maybe you need some other, if that is, this is now. Therefore, I also consider it a little dangerous section, because anybody commits suicide, many people can be roped in. Nearby people can be roped in, who have in connection with the person.
Simply Supreme Court has passed various orders crossing those cases under section 306.
Harassing someone or torturing, that's very bad, of course. Criminal act also.
Something
Abatement, specifically abatement.
And the Supreme Court categorically said that mere harassment will not amount to that abatement or instigation.
Harassment can be a different offense. Abatement is a very difficult thing to prove. Abatement to suicide law, especially very difficult to prove. Actually. That if it does not fall within the statutory parameters of aid, instigation, conspiracy, then you got the legal interpretation, judgment interpretation. left with no option but to commit suicide. That is psychology. And in different situations, same situation, a person may face it boldly and come out of it. Another person might commit suicide. So that is also difficult to generalize.
Exactly, those are the things which have been stated in the judgment which I have referred to.
Anyway, I think at this stage, since they have cooperated, they have recorded their statements. It will be. Let me make it absolute. And so, for application number 482 PNS seeking pre-arrest bail in connection with dispute case number 529 108 PNS. So, accused persons have been alleged to, the accused person is alleged to have abated the suicide of the victim. It emerges from the materials annexed to the bail petition that earlier they had a business relationship, right? Business relationship over an academic institution, private academic institution. The victim apparently left a suicide note, and the purported suicide note has been annexed with the bail petition. This is not in the case diary. The suicide note.
Yes, it's a.
It is there in the case diary. The petitioner was granted interim clearance bail on 4/8/2025. Peruse the narration therein. Case diary has been placed before this court, and PP Goswami, learned additional PP, objects to the grant of bail. Going through some of the relevant flag portions, the case that there are some materials to indicate that as part of the business transaction, there was the accused petitioner allegedly put the monetary pressure the accused on the victim, and ultimately he ended his life. The question of whether the acts of the accused petitioner constituted abatement within the meaning of 106. 106, what is the corresponding section of
Law 45.
45 PNS? Resulting in resulting in suicide of the victim would be a matter of full investigation, and especially a matter of trial based on evidence. Nevertheless, at this stage, I don't deem it necessary to cancel the interim bail granted to the petitioner. As pointed out, he has appeared before the Iowa statement has been reported. According to the interim bail granted by order dated 4/8/25, hereby made absent, subject to the condition that he shall not hamper or tamper with evidence. He shall not intimidate or harass the informant or his family. And he shall cooperate with the remaining investigation. Violation of the law. Return back the case that bail petition stands allowed and disposed of. Very complex. Many things have to be. Sigmund Freud, the famous psychologist, he analyzed the phenomenon of suicide first. So it has many dimensions: psychological, social, legal, medical.
Okay, so it's a petition.
The issue is between husband and wife, my lord. The wife has come back, my lord. Now they are living a peaceful and happy life, my lord. And on that context only, the honorable court has been was big to grant interim bail, my lord.
What was the excuse? uh, File order dated file order dated 22/7/20. This court please to grant interim clearance bail to the petitioner. Only one petition
Yes, my lord.
with conditions. And it is submitted that pursuant thereof he appeared.
Yes, my lord. He appeared.
Statement.
Statement has been
Case
recorded.
diary has been received. Not support. It is going to submit learned additional PP submits that this has been charged sheeted pursuant to completion of investigation. The said circumstances, the interim bail granted by is hereby made absent. Subject to the condition that the petitioner will be available for trial if one commences. And he shall otherwise cooperate with the process of law. Petition stands disposed of.
Deeply obliged.
In terms of a lordship's order dated 8 August, petitioner has already appeared before the investigating officer twice in fact. His statements were recorded and his fingerprints were also taken. Allegation against the petitioner is that lordship the petitioner along with some of his friends, they had taken some psychotropic substance. Subsequently, the son of the complainant, he died. And after 2 days of the alleged occurrence, the complainant lost the FIR out of frustration.
The case diary.
Might be necessary this time.
All the injuries were of body were hemoglobin caused by transfer check.
Injury externally.
Injuries by once we have multiple making quick marks present of our left medial fossa because which mark is covered. They have infected himself in their taking and one another mark together. Apparently, there were multiple confusions of varying sizes, ranging from 3 cm in 1 cm to 1.5 cm given this present over a front of the leg of addresses. I people they are taking substances
Together.
Together.
Yes. Okay. Very yes. The uncomfortable, you know. Children is here, they try to push, place the stage of the distance. Then this one is deteriorated and taken.
They tried to actually save him.
Signs of assault.
No, for a statement of the witness in eyewitness, the assault part is not there.
But medical.
But medical because multiple contusions are varying size, ranging from 2 cm to 1 cm.
Might have had a market also.
They have taken the census in other places. They have taken again come back to their home. They
Again.
Can reject this substances. That is some is deteriorated. But they can transfer them.
Because of that overdose. Because of the overdose of that psychotropic substances. The
What are dated 18 first two paragraphs? First three paragraphs. This is- First three paragraphs. It's submitted by the land council, Mr. Bora, that pursuant to grant of interim, the petitioner appeared before the and his statement was recorded.
Yes.
The same is confirmed by the learned additional PP person, who, based on the received, is there in some extent. The investigation materials lend support to the story alleged in the FIR about the persons taking narcotic drugs together and then narcotics drug together and then subsequently the son of the present, son of the informant, meeting with his death. What has he stated in his own statement? The postmortem report is available.
Yes.
But final opinion regarding death is pending for receipt of chemical analysis report. What is the progress of investigation? We submitted that there is progress in investigation, but investigation is also pending for receipt of the FSL report. In the circumstances, they do not deem it necessary to cancel the interim bail. According, the interim prioress bail is hereby made absolute, subject to the condition that the petitioner shall cooperate with the remaining investigation, shall not hamper or temporarily delay this, and shall not intimidate or harass the informant and his family. Return back the case that the petition stands allowed in this post. Okay, yes, sir.
Here 42 and 43 arising out of same FIR.
42 and 44.
And both are on interim lordship. To my instruction, they appeared before the investigating officer. FIR, your lordship will find page 17. Lordship. Their main allegation is that they received an information that some persons are dealing with betel nuts, lordship, and those were loaded in a vehicle. So accordingly, they went there, and from that go down, they have seized some America nuts, lordship. And my case is that I am having valid license. I have purchased it from different persons. And after lordship gathering all those betel nut lordship, I have sell it to other person after paying taxes lordship. So all those documents I have enclosed with my petition lordship.
The allegation was that it was being illegally carried.
Illegally carried. But I am having all those.
Erica nuts, Burmese Erica nuts.
And lordship, the Jimma of the Erica nuts were given to the present petition of lordship. After obtaining the scientific opinion report, lordship, and scientific opinion report says there is lordship presence of erecoline, which lordship proved that these are lordship that local products, lordship. These are not Burmese products. I have given that copy earlier.
It's a scientific report.
Yes,
It's called scientific report.
yes. That in the Jimma order that observation, probably that order is in the report.
Here?
First date I have furnished to the.
It's part of your bail petition.
No, not subsequently that Jimma order was passed, so I have given it to the. The first page itself, that scientific opinion is there. Enclose the documents from whom I have purchased, that your lordship will find page 22 onwards, lordship. That he has purchased at rupees 146, 144, 145 per kg, lordship, and subsequently he sold it to lordship. Page 28, your lordship get it, that to SA Enterprise after paying taxes, lordship. All those documents are there. The thereafter EWA bill was generated, page 29. And to my instruction, after obtaining interim order, he appeared before the investigating officer and cooperated.
The documents, substantial, and display the documents, those documents were sent to the commissioner. State takes. This is the. State.
Demand report, of course, says that there's no opinion expressed on ownership. It was given on crime notice.
That for all those documents are there.
Let me make it absolute. There's another one.
He is the owner of the vehicle where articles were loaded.
So the one
It's not appeared before. Getting it.
you know, no, that aspect of us, here, there are materials against him. But this so-called contraband was ultimately found to be validly kept as far as documents. And he should have appeared. He should have.
This statement is not before.
Not required.
Give direction, lordship, I give direction, I will implement it. He will appear.
Because the diary will have to be kept.
Yes, it.
Send it back.
Send it back and submit it.
For more proper.
Yes.
The allegations noticed were that Burmese areca nuts were carried in the vehicle without proper documentation and licenses, and they were accordingly seized. The present petitioner claims to be owner of the said materials and contents, and it is contended on his behalf by learned counsel that they were carried in a legitimate manner with proper documentation. In this regard, various invoices, UA bills, including tax invoices, have also been annexed to the bail petition. So, on 12/8/2025, petitioner hearing was granted interim bail, pursuant to which he stated to have appeared before the IO. So this is, he appeared, right? This is confirmed by the learned
Yes.
additional people. Message for. So, it is submitted by the petitioner council that the chemical report is called, chemical analysis report of the alleged contraband has also been received, and it indicates that it contains ingredients which are of the local nature. The same report is available in the case diary. Yes, the same report is also available, FSL report, FSL is called forensic report. It's available in the case diary. Placing order of the learned CGM Lassi. Learned JMFC Lassi Park. It is submitted by the learned petitioner council, Mr. Ahmed. Interim custody of the packs of dried areca nuts were given to the petitioner, present petitioner. In the given facts and circumstances, the interim bail granted is hereby made absent. Subject to the commission, cooperate with remaining investigation. It shall not report out into evidence. Commission expenses. Return by the in this case, in respect of the experience, he was granted the interim on 12/8/2025 with conditions. However, is submitted by prosecution that his statement is not not available in the case there. And therefore, it is not clear whether he appeared before the IO. Therefore, the fresh direction is given to the petitioner hearing to appear before the IO and make himself available for examination. The interim bail shall continue to the next date of listing. Return back the case there to be procured again with the necessary updates. List on 17. List after vacation on 17. Forty-three. I got the 43. Just a minute. I want to be absent. May hereby made absent. 42. Hereby made absent. Take to the two conditions. 42. 4%, and then this we have granted into it's not available.
May I please? 44 alert, this is anticipatory bail application.
And this one is
This, I am not requiring, my file is.
just a minute. They are not connected.
Okay.
Connect.
That is here. This is regular way and production item is
Connected, but that's a regular bill.
regular. My lord is taking item 44. This is my application for pre-arrest bail. Page 10 is the FIR.
Bill AB number 1944.
Yes. Page 10 is the
FIR.
May I read? The informed actually state that my former husband died about 7 years back. At the time of death of my husband, I had a daughter, namely Rajan sir. After the death of my husband, I was facing difficulties for her upbringing. The above name accused assured me to provide all expenditure for her caregiving and schooling. And with such promise, the accused 1 and 2 took my daughter to their house. But the accused, after taking my daughter, engaged her in household work. On 27/25, when I made a phone call to my sister-in-law, she told me that she had received information that my said daughter was died, but the accused did not inform me about the death of my daughter. I have doubt that the accused, by torturing, put her to death. So this is the allegation. The lordship will find
One interest.
admittedly, my lord, when
His
the
name is.
two petitioner, their husband and wife. Our fault is that we have given shelter to a helpless child.
Their house.
Yes, in their house, they were raped from victim.
That is our fault, my lord. They-
No, that's not fault. That's the different thing.
There is sufficient.
But
It was
under 106, evidence act previous. That is, there has to be someone dies inside the house. There has to be an explanation how.
Yes, I have
Trial, no doubt.
paragraph 5 and 6 of my petition. That is my explanation. Paragraph 5 and 6. Page 4. Page 4.
Things exclusively within someone's knowledge. 5 and 6.
paragraph 5 and 6.
Most of the evidence will come into play. So it takes, that's it, this is within a knowledge of the person. It's nice and good to prove that back loss. He needs to give the explanation. Why don't we still do something?
That I have given, paragraph 5.
Also, when it comes to the material.
Just give me, just 2 minutes. I'm just reading the contents 5 and 6. Break up according to you. Break up. Anyway. Fine. And the main allegation is that we had not informed her immediately. In paragraph 6, categorically I have stated. But there were video calls. There are video calls, her position was shown to her. Now your lordship kindly tell, I have also annexed the hospital documents. She was immediately, when we recovered that she consumed poison, she was immediately brought to nearest hospital. That is Dogao Model Hospital. They were treated, some medicines were provided. But since her condition remained critical, she was referred to Nagaon Medical College. We brought her thereafter. I have annexed also Nagaon Medical College document. Wherefore, my lord, Nagaon Medical College referred her to GMC. While in the it was in the midnight, in the morning. On the way. Yeah, on the way she died. So this is our case, my lord, and your lordship kindly consider another thing. The girl was taken 7 years back, according to the FIR. Had there been anything, my lord, where would have been, we had treated her. Had we treated her, my lord, inhumanly, that some allegation must have raised at earlier point of time. After 7 years, that allegation grew. But she was continuously with us. We are, my lord. We are, my lord, issueless. We have no issue. We are husband and wife. So, being issueless, my lord, we are treating her as our own daughter. That part I have categorically stated. So, your lordship kindly consider. And unfortunately, my lord, I cannot, my lord, bring, because in my mobile, the video call was made through another's mobile. So it was not there with me. Documentary. Yeah. Anyway, I'll come back to you. I'll just, yeah.
The statement will even such levels to statement of payment. So the problem is that actuals are there against institutions. Because may I read the statement of the witnesses? You can read it. Joint cases, so it's a joint case.
Can you increase the microphone volume? It's possible. Yeah, better. More volume to that. And I'm adjusting.
Purpose is supposed to be ability for it. They're looking at the windows strategy command on the it took material for the carbon and the company for the against the right. Why? Because the ability to part are supposed to jump on the capacity. After type that two normal size equipment with the capacity over the type of over to us. After simple the capacity of the possibility. Why we say for the it just I feel like that's a tight job. So if we just come on next to this number first, certified powers প্রকাশ সত্ত্বেও অন্য একজন দল কেউ বিরুদ্ধে কিবা জনগণৰ এই সন্দেহযুক্ত কাৰণ তেওঁলোকে সম্পূৰ্ণ কাৰ্যকৰভাৱে বিতৰ্কিত অন্য এখন খবৰ চাপিয়ে বুলি But it doesn't reflect the scenes in buried in some
Another village.
Many other independent witnesses gave the same sort of statements.
Postmortem report is there.
That is. Some of the secretary, metro is very yes.
Actually, last date also 29 before.
Yes.
Mr. Jalan. So case diary is available, postmortem and FSL.
Yes, that is written.
Should we procure that? From which town? This one.
Here, my lord, your lordship has,
Julia is now.
Because the person died.
my learned friend has gone through the statement of the witness. The statement of witness has supported my case rather much. Here only one thing that you have. Let me conclude. Here it appears, she appears to be pregnant. So my case that she was in love, that my lord suffice. That part is over. Then now the next question is that.
Minor.
It's a minor though.
So next part is that why the, we are not her, my natural guardian, man. We are upbringing her, man. She was a minor daughter, girl. Her, the Kaprastan where she was buried, it was her maternal uncle's house, in the area of her maternal uncle's house. Then she was accordingly at the house of her maternal uncle, my lord, she was buried there.
Supposing that this person was a Saiful Islam might have committed sexual activity. Statements were reflected in the court. It's a petty business.
Saiful Islam is the petitioner.
In whose house the business was taken sexual for her operation.
We know that it is there on the paper, we will definitely examine. But if it is there, man, it will be an extreme level of absurd.
Yes.
The POCA, actually. What is called POCA, CD, the note of the investigating officer.
It's a minor. So that's a poverty between duplex. Which is about 10 years.
This aspect gives a different dimension anyway.
Minority and majority is not the issue here. Here whether the present petitioner follow before a motion. We are liable. This is the husband and wife before a motion.
We don't know what this is anyway. So, can we hear the other matter also together? There's another matter.
This is my bail application 2788, madam. This is a regular bail application. Petitioner before lordship is in custody for 50 days, madam. He is the brother-in-law of the petitioner number 1 in the earlier case, madam.
Okay, brother-in-law.
Brother-in-law. So here, my lord, the issue here was that now this girl, admittedly this girl was in the house of the other two accused person. madam. The petitioner in this bail application is not a member of that shared household. Now, whether the victim had committed suicide or whether this is the case, whatever be the cause of her death, madam, this petitioner was not a member of that household. Subject to what is there in the case diary, my learned friend can imagine this on the report. If there is any material to show my complicity in her death, madam. In fact, on that the time, relevant period of time when the victim had died, this petitioner was not even in that area, madam. He was in Guwahati with given documents to that effect, madam. The petitioner went back. When the petitioner went back, it was around the time when this the victim was being taken for her funeral, madam. The petitioner only comes into the picture when the victim was being taken, deceased was being taken for her funeral. So the petitioner before your lordship was not a member of the household. So the presumption under 106 is also not attributable to this petitioner. madam. Secondly, he was not in the relevant place when the incident took place. And further, my lord, now the investigate because he has been arrested. Purpose of his arrest was to ensure that the investigation progresses. The petitioner has cooperated with the investigation and he has already spent 50 days in custody.
I did not, I'm not sure about the name. His statement is here. His statement, Naziru. So, other materials against him with regard to 201.
Yes, that is 201. That would be available.
201 is bail.
Depending 201. The
Depending
current
on
one, which is 238.
Depending on the main
offense.
201 is a standalone offense. But sentence, I'm not sure. That was I'm not sure. Bailable, not bailable, I'm not sure. It is like, it is a standalone, like 149. But
201, my lord,
it
is
may have a relation.
if it's a capital offense, my lord, it remains bailable, my lord.
It will have a relation with the nature of offense.
The IPC was
No, you can see the contents are same. Some these things have not been changed.
if it's a capital offense, it is punishable up to 7 years, my lord, and triable by court of session. Otherwise, it is punishable by magistrate. But in all the three classifications, my lord, according to the statute, it's bailable.
Bailable, non-bailable.
As per this.
Because if it's a 7 years, then it will maybe.
ENSS will pay.
But nothing to do with the sentence, maybe more sentence and still be bailable. Actually, 7 years is.
238 is bailable, my lord. 238 bailable. A is bailable. It's bailable.
New section.
Yes, it is bailable.
Uh, 201 is all three situations that have paid the bill. I think no. I had a feeling that was always comes.
The quantum of sentence may not vary, my lord.
The quantum of sentence varies depending on the main offense.
No, as far as I am concerned, my lord, this 238A, which is the applicable to the main, my lord. In that case, it will fail because I've already spent 50 days on section 16.
Subject to the contract, very easy site, but this statement is there, right? You must have been examined. Once you were there.
I was arrested.
Custody for a long time. Witness. I. Have a look. If necessary, I can take it up after a little while. Meanwhile, I can finish because it's short of time. Slowly it seems.
Executive order, verification 415 of 2025.
Bail is allowed. Technical grounds. Not your bail. Was reserved. Yeah.
Interim have been given, my lord. So in this case, my lord, we have an anticipatory under section 482 of BNSS, my lord. Here the FIR is at page number, my lord. But a type copy is also given in the FIR, my lord. But my lord, there is a separate FIR because there's some typographical error in the FIR, which we annexed here. So I have placed a separate copy of the FIR. My lord, we peruse that, my lord.
At page.
No, my lord. I have given separate copy of the FIR because there is some typographical error in that FIR. There must be one copy at the end.
Type copy of that.
Yes, my lord. So because there is some typographical errors. My lord, I produced the FIR, my lord. My lord, if I may. The FIR is a bit long, my lord. On 6/1/2021, complaining Ashok Kumar Bengani, proprietor.
Then tell me the gist also.
Gist is that, my lord, that
If necessary,
no, my lord, it is necessary because of the case, my lord. Because it's a very commercial dispute, man, because commercial suit has been also filed. Totally civil in nature.
Then fast. Yeah.
Yes, my lord. Petition number 3, 4, and 5. I would also like to say that my petition 3, 4, and 5 has appeared before the IO. Petition number 1 and 2 had not appeared because they are doing some under treatment, medical treatment, which they have sent through the post and it has been received. My lord, they have also given us letters and it was received for. So the case diary, I think, is not updated, my lord, because on 11/9 the case was listed, my lord. And since then the case diary is still with the aligned friend. So they are paying the
Should we extend and get the update?
Yes, my lord. After the petition, my lord, because my lord, month times may be needed, but month time may be needed because of the petitioner undergoing a neurosurgeon, neuro treatment, my lord. My lord may fix at the end of the October month.
In this petition, 5 petitioners have sought pre-arrest bail. And on 28 these are, and they were granted interim bail with certain conditions. It is submitted that pursuant thereof, petitioner number 3 to 5, 3, 4, and 5.
3, 4, and 5 had
have
appeared before
entered
the
appearance. The same is also confirmed by the learned additional PP. So the son. However, petitioner We submitted the petitioner number 1 and 2. We submitted by the learned counsel, you know, Mr.
A.R. Borwa.
Counsel, Mr. Borwa, that petitioner number 1 and 2 could not appear to some ongoing medical treatment.
It has been mentioned in the letter, ma'am.
For which a copy has been sent to the concerned police station and a copy thereof submitted before this court.
Along with the tracking.
Therefore, the learned additional people submits that statements of all the accused persons, all the petitioners would assist the adjudication of the bill. Therefore, in the circumstances, the interim bail granted to all the 5 petitioners is extended till the next date of listing. The case diary may be sent back and procured again in an updated manner. List after the vacation on, you want it in the
End of October, ma'am, because a month time may be needed.
29 or 31st?
29.
29. You want this back or should I keep it? Maybe you have to.
Yes, ma'am.
See.
Pass it up.
Mr. Polito,
I'm appearing on behalf of Mr. Kolda.
your good name?
M. Rahman, my lord.
Sir,
Anticipatory bail application.
I'm first things for charge sheet is
Yes,
relationship issue, relationship. 69 bills. But last order. Last two bills. Last two bills. It will submit on an additional para 4. Submits that charge sheet has been submitted in the case pursuant to completion of investigation. In the given facts and circumstances, the interim bail, is it okay? For some, the interim bail granted to the petitioner by the order dated 28 is hereby made acceptable, subject to the condition that he shall be available for trial for money on commences. He shall not hamper out employment. Bail petition stands allowed and disposed of. Nice. Next.
Lordship, the petitioners are running a rehabilitation center, Lordship.
Rehab
Rehab center. Lordship.
drugs.
Drugs. They are running a rehab center, Lordship. What had happened, Lordship, on 2/8/2025, Lordship. One of the patient of the said rehab center, Lordship, committed suicide by jumping from the top floor, Lordship. Immediately after the incident, Lordship, the petitioner number 1, Lordship, informed the police. Kindly peruse, Lordship, Annexure D, Lordship, page 18, Lordship. Can I go through it, Lordship? And to the officer in charge, Bishwanath Saili Police Station, information regarding suicide. Sir, with due respect, this is to inform you that today at around 8:30 AM in the morning, one individual, namely Rituraj Baru, who was undergoing treatment at our rehab center, namely Pratigya Wellness Foundation, suddenly ran towards the top floor of our building and committed suicide by jumping when our treatment was going on. Therefore, kindly pray before your honor to investigate the matter and take necessary steps in this regard. Thereafter, Lordship, Bishwanath Saili PS UD case number 30 of 2025 was registered, Lordship. On the basis of this FIR, Lordship, a report of supported case of unnatural death was sent to the magistrate, Lordship, as per section 194 of the BNSS, Lordship, which is at page 21, Lordship. Page 21, Lordship.
Right.
Vernacular is at page 23, Your Lordship.
Right.
On the basis of this FIR, Lordship. So on the same day itself, Lordship, the father of the victim, Lordship, submit a Zahar of negotiation, Lordship,
that he has no, that he has no, that he has no, that his son has also, has committed suicide, and he had discharged. He has discharged his he has not discharged any burden on the rehabilitation center, Lordship. On the same day itself, this was done with the petitioner's, Lordship. On the same day itself, on 2/8/2025, Lordship.
It's an agreement.
Lordship. And now Annexure E, Lordship, Annexure E, Lordship. These are the photographs of the said incident, Lordship. Annexure E, Lordship.
Some fair.
So I have round marked the victim, Lordship.
Then somebody lost a
Lordship, then what had happened, Lordship? At present also the rehab center is running with the other members of the society, Lordship. So on 5/8/2025, after 3 days of the alleged incident, Lordship, the brother of the victim, Lordship, lost this instant FIR, Lordship, which is at page 31, Annexure Z, Lordship.
employees of the, your employees.
Lordship, no, Lordship. Oh, he has
Wherever your employees.
Lordship.
May I read? I'll just read it.
Lordship, can I read?
No, I can read.
Lordship. Lordship, now what had happened, Lordship? Kindly peruse Annexure B, Lordship, page 16, Lordship. This is the certificate of the registration of the society, Lordship. And Annexure C is the clinical establishment certificate that is required to run a rehab center, Lordship. And at present also the rehab center is running, at present also the rehab center is running, Lordship, with more than 20 patients, Lordship.
Page?
Page 16, Annexure B, and page 17, Annexure C, Lordship.
Yes, I'll go.
Lordship. At present also the said rehab center is running, Lordship. The petitioner are below 30 years of age, Lordship, and on the date of the alleged incident, they immediately informed the police, Lordship. Photographs also I have attached, Lordship.
Diary has been received.
The treatment was going on.
Treatment was going on.
Yes. Suddenly he stood up and jumped that was upper floor and jump over there. But PM report is not going to be the case there.
Actually, he was undergoing treatment for the last several months there, Lordship, which is specifically stated in the FIR also, Lordship. So at present some perfection may be planned, Lordship. So alert below 30 years.
PM report will be necessary, right? Will be necessary.
Till PM report comes, Lordship.
Mr. Bordal,
Lordship.
Learned Counsel. For the three petitioners, Lordship, who are seeking bail. The prayer has been in connection. Viswanath Soil, 140 by 25.
Lordship.
The factual matrix giving rise to the instant petition is that the petitioners are stated to be running a drug de-addiction center at Viswanath Soil. And one of the patients, Rituras Baro, is stated to have committed suicide, whereupon it was informed to the police by
page 19.
by the communication dated 2/8/2025, leading to registration of Viswanath Soil PS UD case number 30 of 2025, which resulted in a report, copy of which has report dated 6/8/2025. It is submitted by the petitioner side that thereafter the petitioners and the father of the deceased entered into an agreement in which which exonerated responsibility of the petitioners in their organization and their re-addiction center from any culpability in the incident. However, subsequently, some employees of the same of the Procedural Wellness Foundation running the de-addiction center lodged an Azahar dated 5/8/25. Employees,
Your Lordship, the brother of the victim lost the FIR against the.
sorry, I'm very sorry. On Moheswar stated to be the brother of the deceased. Lodged an FIR against the three petitioners herein. With the allegation that when his brother was brought to the de-addiction center, he was assured of being cured, but later his father was informed that his brother had committed suicide. And when his father was not in a proper mental condition, no objections was obtained from him. So, it is alleged that their family members have suspicion that the victim might have been killed. DP Kosami learned additional PP submits that the case diary is received the postmortem report, which is a valuable document in the circumstances is not available. The case diary may be sent back and procured again along with updated investigation and the postmortem report. It will be available by this time, right? PM report will be collected. The learned petitioner council seeks interim protection till then. I've given my consideration to the projected sequence of events, including the intimation of the petitioner side to the police. I deem it fit to allow them to record their statements according in the interim state of list. It is directed in the event of 20,000 each. Budgeted the commission that they shall appear before the file. Make themselves available for examination. They shall not harass or intimidate the informant. Shall you kindly instruct? Yes. Should maintain this. List after the vacation on. Properly investigate. Seven. Can be next week also thereafter. 24th. Let them investigate.
Obligations.
Time of it's okay. Yes, to. Oh, statement. Oh, yes, yes. Separation. So that shit is statement of the. Statement of the. Oh, it is. A separate seat that is not available. Which police station?
It's
No.
My question from this this is a bail application. Like the other case, I am already in custody for 50 days. And from whatever is there in the case, apart, even if my statement is there, whatever be my statement, at the end of the day, the prosecution is going to rely on the materials other than my statement. So if there is any material to show my complicity in any conspiracy to cause the death of the victim, that is the only issue. Otherwise, at best, my lord, even if whatever my learned friend has read out, it only shows that my appearance at the scene at the time of the funeral of the deceased, my lord. If that is so, my lord, then this is a case covered by at best 238A, my lord, which is bail. Subject to what my learned friend says, my lord, 50-day custody perhaps is enough for my, as far as I am concerned.
Okay, let me, first, I want to finish the bails. Let me pass the order tomorrow. But I in the AB. Or madam. Yes, there is receipt. Next. Tomorrow for delivery. Yes, no. The case diary be written. Yes. Because it was very, it had to be exhumed. Exhumed. And the. Saying that I finished the things. Faster, not touch, touch order. 48.
Please, your lordships. Lordships, period bail application, lordship, the allegation are under section 379 and 411 of the IPC lordship. The affair is at page 11. Lordship. Herein the allegation against these present petitioners is that the Delhi police recovered some RRU, radio remote.
Delhi police
Recovered some RRU from our from our possession, and out of the recovered quantity, one RRU matched with the lost RRU, which was complained in Manja PS of Karbi Angalam district. There was already an FIR on 3/4/2024 at Manja PS regarding the loss of 4 numbers of RRU, radio remote unit used in the mobile town. And the matter was kept pending. Subsequently, when the Delhi police recovered some RRU, there was communication to this PS, to this district SP, and accordingly they matched the RRU and found one RRU to be matched. And in this case, what happened, lordship, as I am actually resident of Uttar Pradesh Meerut lordship, the police got issued NBWA against us. So subsequent
PNA has been issued.
No, PNA proclamation has been issued, but that has not been executed. And as per my information, lordship, it has been issued fresh by the order dated 7/8/25 by the London Magistrate lordship. I have not been proclaimed as on date.
That day we have discussed this.
Yes, lordship.
On judgment was also given.
Umesh Kumar it was.
Your side, your junior. Umesh Kumar. Because there will be many cases by this name. So little more detail will be necessary. I'll take it out.
State of
Umesh Kumar versus State of Himachal Pradesh.
HP 567 Himachal Pradesh.
Just a minute. State of HP. Supreme Court decision, right? Supreme Court decision. Supreme Court decision. Citation.
Supreme HP 567 Himachal Pradesh.
Supreme. No, this will be Himachal High Court.
Himachal.
This is a Himachal
There's a
Pradesh.
Supreme Court decision also.
Yes, we can't
No,
fight
actually
there
this-
state of Bihar. We can't fight there versus state of Bihar.
That will be.
If you know, Srikant Upadhyay, it has been discussed that court has the power in exceptional conditions. But in Asha Dubey lordship, this is Supreme Court judgment of 2024.
Asha Dubey.
Yes, lordship. Asha Dubey versus State of Madhya Pradesh lordship decided on 12/11/24. In this case, that the Supreme Court has had that there is no bar.
No, I'll have to.
In case of the
because I think in case of the declared proclaim.
Yes, lordship, in this case, yes, but-
Anticipatory bail will not lie, but I have a doubt whether it will be applicable in the process.
Lordship.
PNA is issued.
PNA
Mostly
issued,
we are
but not
faced with that
executed.
situation. PNA is issued and he seeks an anticipatory bail
Yes,
to
but-
appear. We say face that situation. So this will have to be
Wait,
seen.
corrected, I will appeal lordship.
And this will have to see. CD. It's been
Yes.
received.
Yes, CD.
That part is there, proclamation was issued and
And my instruction is that by the order dated 7/8/25, the PNA has been reissued, lordship. Reissued for report. And it has been fixed on,
Because in that case, suppose it is the entire process, then there will be a bar. The Honorable Supreme Court has said it's a bar, complete bar. So that aspect is to be seen, personally seen actually, whether it will apply to the pending process also. According to you, is it applicable to pending process?
we can't fight their cases, lordship. From exceptional cases, bail can be granted. Otherwise,
Exceptional.
correct. Yes,
so
yes,
actually
yes,
the duty and the conduct of the accused and the background of the case.
It was laid down by the Honorable Supreme Court of in Srikant Upadhyay versus State of Bihar. that a person is not entitled to seek pre-arrest bail when a warrant of arrest or proclamation has been issued. The court can grant pre-arrest bail in extremely exceptional cases, but a person defying orders by absconding is not entitled to the pre-arrest bail. The Honorable Supreme Court, that is.
Then the-
Ashaduke lordship,
this doubt is not there. That means in process also it is available.
but in Ashaduke it is actually otherwise lordship.
So now I'm clear. So it is clear. So now, which means we have to see whether exceptional circumstances
Yes,
exist or not.
available on the paper. What we have to do.
Left, this is 48.
48.
Bail is only completed.
49,
49, along with
Oh.
60.
52 also.
Also.
Oh. So this is the only one. This is the only.
Along with 60, because supplementary.
Ashaduke also is lordship.
Larry, I'll see. Pronounce it tomorrow. Heard pronounce it tomorrow.
Only lordship 379 and 411 is actually, I am a damn owner. So my supposition is that actually from all corners of the.
Because I understand.
Yes, lordship.
Think about that aspect and also learned PPS submitted, of course, now I'm clear about that. But I also have, has the nature of exceptional circumstances been elaborated? No. No. We have to find it yourself. Okay, I'll have a look also. You have the judgment. So hard copy. No. For fix tomorrow for delivery.
I have taken, I never seen that.
You handle it. Because I don't want to delay. Because there's your
64.
you will all get delayed.
Plus.
Sangeeta, this. What does this mean?
May I please your lordship come for the petitioner?
No, it's a very voluminous, it is not sometimes. Fixed. Yes. Yes. Right. What are good? Voice over.
Yes.
Lordship, can you be after the puja petition?
If it is not late for you, if it's not problem for you, I can fix, but there's no interim. There's no interim. Why don't we can get it disposed of? Should I fix? I can fix it after puja, but there's no
Monday.
interim.
Monday.
Okay. Let's try Monday before vacation. Since there's no interim. The matter could not be heard today also due to paucity of time. Still. Is there will be written at least on 22 9.
My lord, item number 51, my lord, I have filed IA, my lord, for correction of the name of the petitioner, my lord. My lord, last month, my lord, that is 18/8/2025, my lord, petitioner was granted bail, my lord. Due to simple mistake, my lord, that is mistake done by the stenographer, the name of the actual name of the petitioner was the Sandeep Das. Stenographer mistakenly typed as Sandeep Das Ansari, my lord. Due to Ansari, my lord, I could not file the bail bond.
Don't blame stenographer. It is also my fault because I have signed. It's my duty to check it. So I'll not shift. It's my fault. I take responsibility. We'll correct it. We'll correct it. We'll correct it. No problem.
Item number.
It was granted by this court.
Yes, my lord.
Correct.
Item number 55.
Correct.
We'll at item number 50.
Just a minute. I make mistake otherwise. So this is correction. Hold on. Which item? Admission. I was planning to try and dispose of something, but I could not even touch. 21. This is interim order is there. 21. Will not be reached due to paucity of time. Interim order granted by order dated so and so stands extended till the next date of list. Interim order, if it does not reach, it's not your fault. So all interim orders will be extended, but it helps to point it out. So this is done. Then next
Item number 54.
54.
The matter may be after tomorrow.
Not the 54. Can you take it on Thursday? Thursday. or day after tomorrow. I have no idea how many.
I
matters
mean,
there is.
maybe day after tomorrow, we will try our luck.
54, not be paucity of time. List on 19.
19. Of life.
Admission. Petitioner counsel is there? Petitioner counsel is there?
No, Your Lordship, we are on interim.
Yes. Yes. Which? Paucity of time, interim bill, interim order, by extended till the next day. Listing, Monday.
Your Lordship, after the petition, Your Lordship.
Has granted 4,000 rupees worship and the court has directed 75%. And from 2018, they have not regularly paid 3,000 worship. And for this, for the information, the respondent could not find enhancement petition. And earlier two of them. They have
Such problems we have. List on 22/9, let's try, fix it. Even if we fix it, there's no guarantee.
Item number 20. Item number 53, Your Lordship.
53,
Yes. Because it is better to settle it for the mediation forwarded by the school parent. And the mediation takes
one of these days
Yes, Your Lordship.
before vacation.
Vacation, Your Lordship.
53 paucity of time. However, learned counsel, the good news is
Yes, next.
submits that matter has been settled in the mediation center. 6 a listing before vacation. List which day you suggested it. Next week. Don't take it very near the end of the vacation, starting. Don't take it very near the end of next week.
Thank
This Friday, take it on 23, 22, 23. Take it.
Your Lordship, item number 20.
Item number 20.
20. Will be fixed on the next week. Except 23rd and 25th.
I don't know what is the nature of the matter. Can it be after vacation? Because I can fix it, but there's no,
Local case is going on. Lordship, that is why-
no interim order.
No.
Paucity of time, list on which day, 2030?
20 except 23rd and 24th.
Oh, except 24? 24/9. Okay.
I think it's number 61. So admission, I think. Can you be fixed on Monday?
Twenty 22/9. Anything else? Next week, we may have many new matters actually.
It's a small matter, no, so don't have to
No
demand-
problem. I'm not doing you a favor by, listing the matter. It's your right to be, matter to be listed, but not reaching, yes, the problem. Next year, next week, we may have many days. We'll try our best.